Morning, Your Honor. Megan Crow on behalf of defendants in this case. This is a friendly suit, a minor prove-up. We have two separate families. That's why we've asked for 20 minutes instead of the standard 15, but we may not take all our time.
Do you need a record or not?
Yes, ma'am.
Okay, it's actually only set for 15, so we'll
take 15.
All right. And are others here on that as well?
Yes, Your Honor.
Shamika Smith.
Good morning, Your Honor. This is Nausha for the plaintiffs.
Good morning, Andrea Carter, attorney ad litem, coverage for attorney ad litem Walter Dean for Shamika Smith.
Anyone else?
Miss Tina Topsy's here also. She's one of the witnesses, and the ad litem is also ad litem for Miss Topsy, or the ad litem.
Okay, thank you.
You bet.
Next up, Fuentes versus Texas Trucking.
Yes, good morning, Judge. Al Silverio on behalf of the plaintiff, Roberto Fuentes. We will need a record, and I think it'll take probably 20, 30 minutes.
Good morning, Your Honor. Chuck Shiver for defendant Texas Trucking. I'd agree with that 20 to 30 minutes.
Okay. Next, we have Global Wet versus Udelhoven.
Morning, Your Honor. Garrett Schultz here on behalf of the defendant, Udelhoven Oilfield System Services, Inc. This is my motion, I believe about 15 minutes, and we would like a record.
Good morning, Your Honor. Lance Coffin here on behalf of the plaintiff and non-movement Global Wet LLC. I believe probably about 15 minutes each would be necessary for this one. So a total announcement of 30.
All right. Okay, next up we have Bricenio versus Wood.
That case passed.
Oh, they did. Okay, thank you. All right, then moving on, Bowman versus Hatchings.
Good morning, Your Honor. Max Crusoe here for plaintiff Rachel Bowman individually as next a friend of Aubrey Bowman.
Your Honor, my name is Sarah McClure. I'm appearing as coverage for Allison Kalis, and we represent the defendant, Marjack Poultry.
Morning, Judge. Luke Dow, guardian ad litem. 10 minutes or less. I don't need a record, but Sarah might want one.
Yes, we would like a record, Your Honor.
Good morning, Your Honor. Reagan Robichaud here to represent defendant H. Hatchings, Inc. as well.
All right, and you think 10 or 15, everyone on board with that?
Yes, Your Honor.
I think so.
Yes.
Okay, great. And next we have McCardle versus Johnson.
Morning, Judge. I'm Price Ainsworth. I'm here for the plaintiff. This is a discovery motion, and we're the respondent.
Scott Taylor for the defendant Johnson. I think Lauren Lewis is the also co-counsel on this one as well.
All right. Who's going to be arguing, Mr. Taylor, you or her?
It should be Miss Lewis, Judge, and I'm going to check and make sure she's on here.
Not hearing from her. So
Let me reach out to her, Judge. It's probably going to take about 15 minutes, I think, based on the argument.
All right. Anybody need a record?
I don't think they do need a record.
Okay. Well, y'all are at the bottom, so plenty of time to track her down.
Thank you, Judge.
All right. Thank you. I am going to ask everybody who's not here on Smith and Topsy to go ahead and turn off their video so I'm not scrolling through 20 different Brady Bunch screens. Smith versus Pitts. Counsel, you may proceed.
Megan, you're muted.
I appreciate it. I'm going to go ahead and call the witness and ask the questions on behalf of the ad litem and the attorney for the witness. I'd like to call first or the mom for Janiyah Topsy. You're muted, ma'am. While she's unmuting, Your Honor, this is a minor prove-up settlement for injuries sustained allegedly as a result of an accident that took place in August of last year.
Hello.
And settlements have been reached for 2 minors, including 2 young adults. So we're doing the prove-up for the 2 minor. And are you the natural mother of Janiyah?
No, I'm her legal guardian.
Okay. And what's the date of birth of Janiyah
1908
and her current address?
18617.
Thank you. On August 28th of 2003, was Janiyah injured in an accident?
Yes, she was.
And do you understand that the specific details of her injuries include headaches, cervical, thoracic, and lumbar strain sprains?
Yes.
And is it your testimony that she has recovered or intends to fully, her doctors say she will fully recover from the injuries that she sustained in that accident?
Yes, she will recover.
Okay. And you have reached an agreement to resolve all the claims that you have outstanding against Pitts Construction and William Pitts. Is that correct?
Correct.
And it's the understanding of all parties that the carrier on behalf of Pitts Construction and William Pitts has agreed to pay $11,500 to settle all claims against them.
Okay.
Do you understand that?
Yes, I do.
And is that your agreement?
Yes, it is.
Okay. And you agree that this settlement that's been reached is in the best interest of Janiyah?
Yes, I do.
Okay. And you understand that this is all the money that Janiyah will receive as a result of this accident on behalf of Pitts Construction and William Pitts?
Yes.
And it's your understanding and agreement that you will be signing a compromise settlement release and indemnity agreement codifying the settlement that's been reached in this case?
Yes.
And you're here before the court asking the court to approve of the settlement. Is that correct?
Yes.
And it's my understanding that the outstanding medical that's been compromised in this case is $6,393.10. Is that your understanding?
Yes, I know. Yes.
And you're asking the court to approve the settlement in this case?
Yes, I am.
Okay, I'll pass the witness.
No questions, Your Honor.
Okay. Ms. Knight?
Yeah, I think the numbers were switched. The 11,500 is actually for the other minor. It's 18,000 for 16,800 for the Miss Topsy's guardian.
All right, Ms. Crowe, do you want to clear that up?
Yes, thank you for that, Nasha. The settlement that's been reached, Ms. Tipsy, on behalf of Janiyah, $16,800. Is that your understanding?
Yes.
Okay. And you're asking the court to approve the settlement in the amount of $16,800 on behalf of Janiyah. Is that correct?
Yes.
Okay, pass the witness.
Anybody have anything else?
No, Your Honor.
Okay, counsel, I'm going to need a breakdown on what is being paid as far as attorney's fees versus what the child will recover.
It is my understanding, Your Honor, that Mr. Dean will be receiving $750 that will be paid out by the insurance, and that will not affect the child's settlement.
Okay, that's not what I asked, though.
I'm sorry. All right.
What percentage of recovery are the plaintiff's attorneys receiving?
Yeah, Your Honor, I can give you the breakdown. So for Janiyah, the offer is 16,800. Attorney fees is going to be 5,203.45 cents. We have taken reductions on the attorney fees to 30.97%. Case expenses are 649.85 cents. The medical expenses, which will be also paid out, would be totaling to 5,743.25 cents. And the amount that will go for court registry would be 5,203.45 cents. That gives the breakdown.
Okay, thank you. So it's less than a third a little over 30% for attorney's fees.
Yes, it's generally 33.33, but we are taking reductions on the attorney fees.
Okay, thank you. All right, Ms. Crow, do you want to call your next witness?
Yes, Your Honor. Defense calls Miss Smith. And are you the natural mother of Shakira?
Yes.
The date of birth of Miss
2908.
and the current address for Shakira? And is it your testimony that on August 28th of 2003, Shakira was involved in an accident and injured as a result of that accident?
Yes.
And is it your testimony that the specifics of her injuries included right shoulder pain, cervical and thoracic strains, and a sprain of her right shoulder?
Yes.
And is it your testimony that she has fully recovered, or the doctors have concluded that she will fully recover from the injuries that she sustained in the August 28th, 2023 accident?
Yes, she will recover.
Okay. And is it your understanding that the agreement reached is that the carrier on behalf of Pitts Construction and William Pitts has agreed to pay $11,500 to settle all claims as against Pitts Construction and William Pitts?
Yes.
And it's your agreement that this settlement is in the best interest of Shakira?
Yes.
And do you understand that this is all the money that Shakira will receive on behalf of Pitts Construction or from Pitts Construction and William Pitts as a result of this accident?
Yes.
And is it your agreement that you will be signing a compromise settlement release with indemnity agreement reflecting this settlement?
Yes.
And you're here today to ask the court to approve of the settlement that's been reached?
Yes.
Okay, I'll pass the witness.
Okay, anyone else?
No questions, Your Honor.
Questions?
Okay. And can you give me the breakdown, counsel, of what percentage is going to attorney's fees versus medicals on this settlement?
Yes, Your Honor. So the offer, as I said, it's 11,500. Attorney fees would be 3,751.30. Again, taking reductions on the attorney fees, and from 33.33, it will be going down to 32.62%. Total deduction of case expenses would be 595.72 cents. Medical expenses that will be paid out would be for 3,401.68. Amount that would go for court registry for Shakira would be 3,751.30 cents.
Right, Ms. Carter, let me ask you a couple of things. Where is Mr. Dean?
Mr. Dean is in trial with Judge Maya Guerrero today at 9 o'clock.
Okay. And I know we don't have any jury trials going on other than
It's a trial with CPS, is my understanding.
Oh, a long docket case. Okay. And in looking at the file, I only see one guardian ad litem for the minor J.O. I don't see that he or anyone was appointed to represent the other minor.
Your Honor, I was a little confused as this testimony was going on this morning. My understanding from Mr. Dean was that he actually represented the child with the surname of, so I was sending a message to him to ask about. But his response to me was that he had spoken with both of the clients, his clients, and so I can only assume that he thought he was appointed for both. I cannot state that as a certain.
And what do you know about this case?
I know nothing, Your Honor. I'm just helping the colleague.
Okay. So the purpose of guardian ad litems is to review the file, speak with the parties, evaluate the case, and come in and tell the court what is or isn't recommended. I'm not really sure that
I can state, pardon me for interrupting, I may state that Mr. Dean has shared with me that he has reviewed the pleadings, the demand for the settlement. He conferred with the plaintiffs and their representatives, and he approves the settlement.
Okay, well, all that is hearsay. So, I mean, this is not really the way things should be done, frankly.
Well, I'm standing in as coverage as an attorney for Mr. Dean, so I'm not certain that that would be considered hearsay. That would be me just sharing with the court what my.
Okay, well, you don't have any personal knowledge and you aren't the guardian ad litem, and one child does not have a guardian ad litem. So let me go back to Ms. Crow and you let me know how we can fix what you have brought today.
Thank you, Your Honor. And I apologize. I'm just appearing today too. So the attorney that filed the friendly suit and filed the request for guardian ad litem isn't available this morning. It was my understanding that Walter Dean had been appointed as guardian ad litem for both and that everything was in place. I spoke with him earlier this morning and he relayed to me that he had reviewed the file and approved the settlements as well. And that was my understanding from speaking to the minor's attorney, Ms. Knight, this morning as well. So I'd like to move, if it's possibility, since he has reviewed both files, to have the court appoint him as the guardian ad litem for the minor as well, if that's not on record already.
Mr. Dean, I'm sure would be in agreement to taking on the role as guardian item for both minor children.
Okay, I'm just looking through your file. And let's see. You only have a motion relevant to one minor for whatever reason, probably because it's a bad form and someone did a bad cut and paste. So we don't have oral motions to appoint guardians. When you come in for the hearing on approving a settlement, I's need to be dotted, T's need to be crossed, and that is not the case here. So I've heard the testimony, but I don't have a guardian here appointed for both minors. I don't have a guardian here making a recommendation. So I think y'all need to file a motion asking for a guardian to be appointed for the second minor and reset this hearing. And appearance counsel is not, I understand y'all are just here filling in. Sometimes filling in isn't the best place to be, especially when the people you are filling in for haven't done what they needed to do. So I am not going to approve the settlement.
Thank you, Your Honor. We'll reset. We apologize for taking the court's time this morning.
That's okay. Just before you come in on something like this, you need to pull the court's file and confirm whether everything has been done. A quick review shows one order for one minor, and that's about it. So y'all are excused.
Thank you, Your Honor.
004646. Counsel, go ahead with your appearances.
Yes, Al Silverio on behalf of the plaintiff, Roberto Fuentes.
Chuck Schreiber for the defendant, Texas Trucking.
All right, and the movement may proceed then, Mr. Silverio?
Silverio.
Silverio. Okay, go ahead.
Good morning, Judge. This is a motion to compel. We're also asking for sanctions as well due to some just conduct that we'll discuss here in a bit. But just to give you a little bit of background about the case, this arises out of a construction injury that took place at a Jimmy Evans work site down in Buda. Basically, the defendant, Mr. Ulloa Sanchez, was driving an 18-wheeler for his employer, and he's essentially dumping material from his trailer onto that Jimmy Evans job site. He finishes doing that, and somebody there at the job site, we're not sure who yet, we're still in the process of discovery, but that individual lets Mr. Ulloa Sanchez know that, hey, there's still material in the back of your trailer. So Mr. Sanchez goes on to continue dumping. He's now moved to a different location and begins dumping the remainder of his materials. Problem is, he does that on an uneven surface, so the entire trailer and its contents tip over onto our client's the hood and cab of our client's 18-wheeler. So we filed suit on this case against the driver of the 18-wheeler, Mr. Sanchez, filed against Jimmy Evans, who's the owner of the job site. And we also filed against defendant Texas Trucking, who's here today, as they are the dispatcher, and it's our understanding that they were kind of overseeing and running the job site. So that's a little bit of background about the case itself. Now, what we're asking for, Judge, in our motion to compel, we issued pretty standard discovery requests. We asked for things like incident reports, disciplinary measures taken as a result of this incident. We asked for any excess insurance policies, among a number of things. I'm happy to go down them one by one if you'd like to do that, Judge. But basically what we've kind of faced on this case, dealing with counsel thus far, is even us getting the insurance policy that's required by the initial disclosures, that was an uphill battle. Counsel for weeks refused to produce that to us, even though there's no objection to be made there. And finally, they did produce it. But now, we reviewed defendant's discovery responses. Essentially, nothing was produced. There's just boilerplate objections and assertions of work product and attorney-client privilege that are improper under the rules. We attempted to discuss our issues with the discovery deficiencies with counsel, and the response that we were met with was, we're standing on our objections, go ahead, set it for hearing. I hear the court setting hearings in February. So I hate having these hearings. I don't think that they're productive, and in fact, I was able to hammer out these issues with the other three defendants in this case. But we haven't been able to do that here today. So we're here asking for you to rule on these objections and assertions of work product and attorney-client privilege.
Mr. Schreiber?
Thank you, Your Honor. A couple of facts that are important you need to know about. He has described the accident, how this happened. One truck rolling over, some sand poured through the window on the plaintiff's truck, and this is an extremely minimal damage case with basically some sand spilled on this individual. He pointed out there that we all know who the driver of the other truck was. We know who their employer was. We know who the owner of the equipment was. We know who the premises owner was, and we are none of those. We're a non-involved party in this case. And plaintiff should note that his own pleadings have pled only that we dispatched the truck. That's false, number one. And number two, it's also irrelevant. And as you see, as we get into a lot of these requests here, why we've taken the position, and frankly, I object to the other side claiming the position that if we follow the rules of civil procedure, that that's somehow obstructionist. We have a motion for summary judgment that's pending, and right after that, a frivolous, groundless pleading sanction motion is going to be pursued. We have a case here that's been on file for 1 year and 4 months. He hasn't taken a single deposition. He's done nothing to be diligent about moving the case forward, but he has time to come after a non-involved party for this kind of nonsense. I have multiple serious fatality cases where plaintiff's attorneys don't go after the claim file and reservation of rights letters, but that's what we have here. Now, in this case, 5 of these requests today that are disputed relate to privilege. And the plaintiff's attorney seems to have a complete fundamental misunderstanding of privilege. He's asserted that it only applies once defense counsel is hired. That is incorrect. He seems to believe it only applies to communications between the defense counsel and the defendant, and that is also not correct. He has here asked on 5 of these disputes for incident reports. And of course, we have lots of objections about what that means in the first place. But if we come down just to the core of privilege, we've provided the affidavit of the adjuster, Todd Hasty, that's an exhibit here uploaded to Box and also provided to the court counsel or the court personnel ahead of the court today, who's noted when and how the case was first revealed to the company, that the anticipation of litigation was on March the 5th of 2024, when the facts of the case were revealed by the plaintiff's attorney himself. So clearly, this affidavit, which is not contested and can't be contested by the other side, is that the reasonable anticipation of litigation occurred on March the 5th, 2024. Everything after that is in the way of communications between and among the insurance company, the insured, and or defense counsel and or other agents is all privileged. I've tried to explain this repeatedly, but I think the fundamental misunderstanding of the law applicable to privilege here is the impediment to why this hasn't been able to be resolved. We have no material that is not privileged that might be described by this very broad term that he keeps using of incident reports or investigation reports. So we have established the date of reasonable anticipation of litigation. We have said that we have withheld material that was created after that date, that was communications by and between the insured, the insurer, the agents, and or defense counsel, and have properly asserted privilege to those things. So again, we have no non-privileged material to produce. So that's just one, and we have arguments about several of these other specifics as we get into reservation of rights letters and other complete irrelevancies in the matter. But I think the first point is that we have asserted privilege. We properly stated that we were withholding material described in our privilege log as communications between the insurer and its representatives. And we've stated the date of anticipation of litigation and that there are protected materials and there's nothing else out there that's non-privileged, so nothing to produce.
And Judge, if I may.
Okay, yes, you have the final say.
Yeah, so just a few points there. We're obviously not asking for communications between, defense counsel and their client. That's obviously covered by attorney-client privilege. We're not asking for those kinds of things. The suggestion that, that their client has absolutely nothing to do with this. Well, our client contends that there were Texas trucking employees there on site that were directing the job, what was happening at the construction site. And in addition to that, there's also a indemnity agreement signed between Jimmy Evans and Texas Trucking, whereby Texas Trucking agrees to oversee operations there at the job site. So there's involvement there. As far as depositions, we're working on getting those scheduled right now. We're trying to get them done in January or February. The case is set for a separate trial on May 5th. So there's still discovery to be done. I mean, there's outstanding discovery requests right now to all 3 defendants. So there's still a lot that has to be uncovered in this case, and frankly, we haven't received any. The only thing that defense has produced in this case is an insurance policy. I mean, incident reports are discoverable. I mean, that's information that we routinely ask for in discovery, and it's not covered by the work product privilege. Obviously, under the rules, there's exceptions to the work product privilege. And one of those is when there's statements about what happened, photos, videos, that's in the actual letter of the statute. So we can't hide incident reports and disciplinary reports and training reports that were made subsequent to this incident under the cloak of this is work product privilege. And again, all the other defendants in this case, they didn't lodge those objections. They simply said, no, we don't have them. So it seems striking to me, that if you look at the photos of this incident, it's an entire large 18-wheeler trailer that fell on our client's tractor trailer. This isn't a minor incident. So we know that there's an incident report out there. None of the other defendants have it. It appears that Texas Trucking is the party that has it because they're claiming that they're withholding information. So really, we're just trying to figure out, who has what, and incident reports are just not covered. Incident reports, disciplinary action, those aren't things that are prepared in anticipation of litigation. They're just simply things that document what happened. There's no strategy there. There's no mental impressions of attorneys. It's just documenting what happened. So that's all we're asking for here is, and I'm happy to go through each of those one by one, Judge. But however you'd like to handle that.
Okay, yeah, if you're looking for rulings on discovery requests, I'm gonna need more than a vague statement about what they are.
Sure, we're happy to go through them one by one.
And have y'all conferred about these?
Well, I tried, Judge, and the response was, we're standing on our objections, set it for hearing. I hear the court setting hearings in February. And I mean, we did correspond back and forth after that, but I mean, I'm sorry.
Yeah, I think you need to bring them up. Share your screen.
Sure.
Tell me what's in contention, and we can go through them one by one.
Sure.
But you'll only have 30 minutes total, so you need to get moving.
Yes, Judge. So we'll scroll since we're pressed for time here. Here's the first one. All investigative reports related to the incident in question, including documents, memorandas, photographs, videotapes, movies, statements, reports, drawings, tangible things attached to them. Again, this is an investigative report. It's just, correspondence, emails that discuss the incident. We're not looking for anything prepared by, counsel. And again, we're looking for items that just discuss what happened. We're not looking to figure out what strategy is there. We're looking for things like witness statements of persons with knowledge of relevant facts and photos and videos. That's direct from the exceptions to the work product rule under 192.5C. That language is directly from the rules.
Judge, if I may, if you'll scroll up, if you'll scroll up a few sentences there, he'll see that our response in the discovery was, we're asserting privilege, but as to the exceptions for photographs, videos, statements, and so forth, see the other responses where we provided that material. We know what the exceptions are, and we've provided all of them. What's left is the communications. Again, he seems to think this is limited only to communications between the defendant and counsel. That is completely wrong. If the insurer exchanges emails with the insured from the point where they know there's a reasonable anticipation of litigation, even though we haven't been hired yet, and that could be an exchange of emails about what was going on and what their opinions are as to what took place, that is fundamental work product privilege. Okay? So does it have to be core work product established by a defense counsel? No, but that's not what the rules apply. So we have provided the exceptions to work product. We provided all that material. He didn't point that out, of course, but his own response there shows that to be the case. So the only thing that is left is communications by and between the insured and their representatives, insurers, agents. That's what we've asserted privilege to. That's a proper assertion, and we've provided the affidavit from the adjuster to establish the date of anticipation of litigation, which he has done nothing and can do nothing to dispute. So what's left is the communications that are in the claim file. That's all it is. We've identified them as such in the privilege log, and we've properly asserted the privileges that are applicable here. So there's nothing left that is non-privileged to produce.
And Judge, we haven't received anything in response to this request. I mean, we did not receive an investigative report. We didn't receive any of these things that we asked for. Nothing was produced. Just to be very clear, there was no documents were produced responsive to this request. In fact, no documents were produced in response to any of our requests. So that's simply not true that that these requests were responded to. I mean, we didn't get a single investigative report. We didn't get a single photo. We didn't get a single statement. Nothing. I mean, and we're not asking for communications between the insurer and you know and the client. What we're looking for, and even then, there's an exception to that rule. There's witness statements and statements of any persons with knowledge of the relevant facts. There's an exception to the work product rule for that. I mean, this is why we get all the time in discovery, we get emails, internal emails between employees of defendants discussing what happened, text messages, you know, memos, documents. That's all information that's discoverable. And it's not prepared in because there's litigation afoot. That's just information that companies keep to document what happened. That's the purpose of an incident report, is to document what happened. And that's discoverable. I mean, it's very clearly right there in the exception of the rules.
Judge, our response there, as I said, scrolling up a few lines, says for photographs, videos, discoverable witness statements, see the other responses to requests 1 through 4. So to the extent we had anything that is an exception to work product, we have produced that. But correspondence between the insurance company and the insured is not discoverable once the anticipation of litigation is in place. And that certainly that was very clearly established here, because the plaintiff's attorney called and described this horrendous event on the date of March 5th of last year. So anything after that, and again, communications between the insurance company and the insured do not fall into the description of a discoverable witness statement. So he's completely wrong about that. But coming back to the bottom line here, we have nothing that's not privileged. So there's nothing to produce. To the extent there were things that are exceptions to work product privilege, we produced them. Why do we have nothing else to produce? Because we weren't there, we weren't doing anything. And I'll tell you a minute ago, he now says we were there and overseeing the site. That's the first time I've heard that. And he certainly hasn't pled it. In a year and 4 months since he filed the case, he's never pled that. But we weren't there. We don't have anything to do with this. And that's why we don't have anything except privileged material within the file that was created after the date of the reasonable anticipation of litigation. So this is a simple matter. These materials are privileged. We don't have any non-privileged material to produce about this. And his statement that correspondence between the insurance company and insured is a discoverable witness statement patently does not comply with the description of that in the rules.
Okay, and let me just ask, Mr. Schreiber, because I think your opposing counsel indicated nothing has been produced. If that is true, does that indicate to the court that you have no photographs, you have no witness statements, video, etc.?
We obtained some photographs after the fact, and so we're quite aware that there are exceptions to the work product privilege. So if there were photographs, videos, witness statements, if we had them, we produced them. If we didn't, then we didn't have them. We have nothing. Because again, we found out about this about, I believe it was about 9 months after the accident. And because we weren't there and we weren't involved, and again, the responsible parties, the driver of the other truck, the owner of the truck, the employer of that driver, the owner of the equipment, the premises owner, are all defendants in the case, and they are none of us. So why would we not have anything really about this case, or have very little about this case? Because we weren't there, we weren't involved. But as far as privilege goes, if we had material that fell into the exceptions, then we produced it. If we didn't have those, we didn't have them to produce. We didn't. So that then leaves only what's left in the privileged claim file that we have not produced, and believe that we are on solid ground legally in protecting that privileged material.
Yeah, again, Judge, nothing has been produced. I mean, if you look at the Bates labeling from defendant, I don't even know what number there would be. There would be the insurance policy that they reluctantly produced. If the answer is we don't have anything, then we don't have anything. That's fine. If the answer is none, it's none. But clearly they're withholding information that is clearly laid out by the rules that it's discoverable. And I mean, they're claiming that we weren't there. That's not my client's contention. My client contends that he saw Texas trucking people people wearing Texas trucking gear, so to speak. He saw Texas trucking vehicles at the site. So, I mean, the contention that they simply weren't there, that's up for debate, right? I mean, that's in dispute, right? And it's it's interesting to me. In this case, everybody says that they don't have anything, and all the other defendants did was, because I picked up the phone and talked to counsel for every single other defendant in this case, and we went through their objections, and they simply removed them and said none. So it's odd that every other defendant just agreed to remove their objections and said none in response to the requests that we made. And the only defendant that's standing on their objections and clearly withholding information is, fighting us on this. Again, there's a contractual agreement between them and the job site owner whereby Texas Trucking is supposed to run the show. They're supposed to oversee the entire operation there. So to claim that their client, that Texas Trucking wasn't there and wasn't doing anything at the job site is impossible. I mean, there's a contract that literally says that they're supposed to run the job site. So
that is not what that indemnity contract says. It's a standard indemnity provision. And frankly, the reason why nobody's following up on it is because of the anti-indemnification statute. So learn some law about that issue, number one. And two, I find it interesting that as your story keeps growing.
Stop you right there, because you need to be addressing the court and not opposing counsel.
We keep having the inference here that we're hiding something because we haven't produced anything. The fact is we weren't involved, and so we don't have anything to produce other than what's in the privileged claim file.
Okay, this request number 5 is denied. The motion to compel is denied as to that request. Move to the next one. And y'all only have about 7 minutes.
There are 5 requests that all basically the same thing where we've asserted privilege. It's just different versions of incident reports, etc. But there are 5 that are the same thing.
All right. Mr. Silvero, is that the case that they're all really, you're seeking? If we're all here on the claim file, then I think you have your answer on that.
Just so you know, it's RFP 517.
So, Judge, we're not asking for the claim.
22.
We're asking for
25. And 41.
Yeah, so Judge, we're asking specifically for, we're not asking for the entire claim file. That's privilege. We don't want the claim file. We're asking for investigative reports, incident reports. That's request number 5. Number 6, a copy of each and every umbrella policy.
I'm sorry. We're trying to wrap this up in 7 minutes. There are 5 requests for claim file materials. 5, 17, 22, 25, and 41. And I think the court's already ruled on number 5. If I'm hearing the court correctly, it would be the same. They would deny the motion to compel on the other 4.
Judge, if we could just kind of go through these in chronological order, I think we can get through them pretty quickly. Is that okay with the court?
I am going to cut you off at 30 minutes, so you can do your best.
Understood. So number 6, we're just asking for any and all insurance policies under the rules. They have to produce that. There's no valid objection there.
And they've already done it, is what your motion said. You did get the insurance policy.
Right. Yes, we have the primary insurance policy, but if there's any other coverage there, that's also discoverable.
Well, it depends on what you pled in your pleadings. You don't just automatically get an excess policy.
Sure. So we pled that the case is worth, we're asking for damages in excess of 1 million and below 5 million. So the primary policy they produced is $1 million.
Judge, we have from the parties who there's at least an arguable case of liability, the owner of the other truck and the driver of the other truck, they've identified $3.5 million in coverage. This guy had $20,000 in past medical until he, fluffed up the expenses with some objections recently. But that's $3.5 million of coverage. We've identified $1 million in our underlying policy. And whether or not there's any policies beyond that, there would never be any hope of them being reached. So you're right. I agree. We've provided them $1 million. That means they're aware of $4.5 million in coverage right now in this minimal case.
Okay, if the pleadings ask for in excess of the primary, then you have to give the excess policy.
I'm sorry, if the pleadings say what?
If the pleadings are for $5 million and you've only given a $1 million policy, I think that makes any excess policy discoverable. I don't have the pleadings, that nobody has mentioned that one way or the other, so I don't know what has been pled.
I'm just pulling that up here.
Judge, and again, we're pressed for time. If we could just kind of move through these, if that's okay with you. Number 7, we're asking for other incident reports that took place in the last 10 years. We're asking for that because it could show a pattern of conduct of other negligence or recklessness and nothing being done about it. So we're asking for that to be granted.
Okay,
Judge,
that was denied. That's overbroad on its face. It's not reasonably tailored. The time period's overbroad, not substantially similar to what happened here. No, move on.
Judge, the pleading does say relief over 1 million, and we have
Okay.
4.5 million already identified. So we would argue if there was an excess policy, it wouldn't be relevant.
It's not discoverable based on the pleadings at this time, so.
Okay.
14, criminal records pertaining to plaintiff or any other witnesses. The responses will supplement and hasn't been supplemented.
Well, Judge, that plaintiff just supplemented some discovery and said we'll supplement. So that's an entirely appropriate answer. When and if we have something like that, we will supplement.
Yeah, I don't see anything for me to rule on there. I mean.
We can move on, Judge. Just request for time. Number 17, any incident reports that pertain to the actual job site here. I think that's clearly relevant. It's the actual job site where this happened. So any other accidents or injury events there in their possession.
Judge, this isn't even limited to us. It could be other parties. What time frame? It's not even in there specifically. And so again, incident reports. This is another that falls into the privilege section. This is another one of the 5 requests where we've asserted privilege, and you've already denied the motion to compel on number 5. We would suggest this is the same thing.
And Judge, we did limit it to their possession, and then this job site is actually complete now. It's like an apartment complex or a condo complex. So there wasn't work being done there for 10 years. This is pretty limited. Anything in their possession that happened at this specific location.
Ever, it appears, right? And involving who or what?
Texas Trucking, any documents in their possession, Judge.
Okay, it's denied.
Okay, the next one is 18. 18 and 19 are both asking for employee manuals and safety manuals. If they didn't follow their own rules and procedures, then that's evidence of negligence.
Rules about what? The only thing that he's pled is we dispatched. And of course, there is no negligent dispatch cause of action. So he wants just any employee or safety manual regarding anything that the company does. And the only thing that he's pled is that we dispatched these trucks.
And again, Your Honor, our contention and discovery is ongoing. We'll amend our pleadings as we get more information. But our understanding is that Texas Trucking was there kind of running the show. So their policies and procedures are irrelevant.
Funny that counsel has not pled that, Your Honor. That's outside of the pleadings. It's an argument that's been developed for this motion to compel today. These requests about employee manuals about any subject, there's not even a time frame listed for them. I mean, if he wanted policies and procedures related to dispatch, which is something that he's pled, then fine.
Again, Judge, discovery is not that limited. It's broad. I mean, we're just asking for employee and safety manuals.
That's exactly the problem. It's the overbreadth of these.
Okay, I am going to deny the motion to compel us to these 2.
All right. The next one is any documents relating to an agency regulatory agency investigations or citations or warnings from January 2014 to the present. Again, that's evidence of any kind of negligence, not following the rules essentially within the last 10 years. We think that that's relevant, again, to show if there's a pattern of conduct there, of negligent conduct.
Judge, this is the very definition of a harassing, sanctionable discovery request here. Every regulatory issue, investigation, citation, warning, regarding who? About what? For 10 years? I mean, the incredible overbroad scope of this and the total irrelevance of all of this, and not even limiting it in any way to the negligent dispatch that he has pled, this is just an absurd request and an example of why we've had a breakdown in communications here. I mean, we weren't in a position to remove objections that were issued in good faith and in compliance with the rules, and this is one. Vague, overly broad, irrelevant, and especially not in having any limits as to who and what about, and for 10 years for a party not involved in this event.
Okay, so the motion to compel is denied. And if this is your form, Discovery Council, I think you need to consider spending some time rewriting it. Anyway, y'all have reached 30 minutes. Is there anything that remains?
There's still a few. There's 1, 2, 3, 4, 5, 6.
Okay, well,
there's
a bit of a
about
rhetorical question. Is there anything different? Is there anything that you really think you're entitled to that you don't have and you're asking the court to compel? Because based on the discussions we have had, I now see why defendant has stood on their objections and required the hearing.
Judge, there is one area we want to make sure we do get a ruling about today, and that's 2 requests for production related to reservation of rights letters. And I've attached the NRA Madrid case that we uploaded to the box and provided copies of for everybody, which makes it quite clear that that is non-discoverable.
Yeah, Judge, and we think that that goes to, for example, if that goes to the collectability of any judgment that's out there. If there's no coverage here, then we're entitled to know that information because it affects our ability to collect on a judgment.
Well, Judge, in that NRA Madrid case there, we cite what the Supreme Court's position is, which is, quote, determining the settlement value of the case is not related to the merits of Calvillo, that's plaintiff's negligence claims, or to Madrid's defenses in the case. And there's no showing the information appears reasonably calculated to lead to the discovery of admissible evidence. So it's privileged and it's irrelevant. And the Supreme Court has made that quite clear. It's outside of the scope and existence of an insurance policy.
Okay. I never understood why people don't disclose these, I think, but that's more of a personal opinion than anything. Insurance isn't going to lead to the discovery of admissible evidence. Mr. Silvero, do you have a response to the case that counsel has cited on those reservation rights? Because I haven't seen anything new on that in a while.
I do not, Judge. I do not.
Okay, then I don't think you are going to get them.
Okay, there's just a few here that I'd like to cover with you briefly. I believe you said you denied it as to incident reports, training reports, so I guess we can skip that. We asked here in interrogatory 4 for them to identify any personal injury lawsuits filed against them in the last 10 years. Again, we're trying to see if we tailored it in terms of temporal scope, and we limited it to personal injury lawsuits. We don't want to know about business disputes, breach of contract, anything like that. And again, if there's a history of negligent or a pattern of negligent conduct there, we think that we're entitled to that information as well, and the jury's entitled to see it.
Boy, Judge, any personal injury lawsuits filed against Truckee for 10 years for anything, for what? Not even remotely limited to what might be the facts of this case about dispatch and so forth. So again, another extremely overly broad and irrelevant request.
Okay, so I think 10 years on its face is overbroad, and I think there's a very old Texas Supreme Court case on that point exactly.
And Judge, we're happy to limit it to 5 years, say.
Well, I am not here to rewrite your discovery request. I'm here to rule on the motion, and so it's denied.
Understood. 7 is essentially identical. And then on 10, we're asking, have all the insurance policies been disclosed? And we did not get a response to that. Again, this one goes to excess coverage.
I think judges, you already ruled on this issue of the policies.
Yeah, I think under the current pleadings, you have the policy that you're entitled to at this point in time, so.
Right, Judge. That's basically all I have. So nothing further from our side.
Okay. All right. If somebody wants to put together an order, I will be happy to sign one, or you have the rulings on the record, but I think you have what you need.
Thank you.
All right. Y'all are excused from the virtual courtroom.
Thank you.
Thank you. Udelhoven Oilfield System Services. Go ahead, counsel.
Good morning, Your Honor. I'm Garrett Schultz. I'm here on behalf of Udelhoven, and this is my motion.
Okay, yes, and I'm familiar with it, so you may proceed.
Thank you, Judge. So, Judge, I think the issues here are pretty straightforward. It's our motion to move this case from here in Travis County over to Blanco County. 2 primary reasons for that. The property and the project is located in Blanco County, and the contract also has a mandatory venue provision that dictates that Blanco County is appropriate. Plaintiff's whole assertion on this is that the substantial events related to this quote, this proposed liner that they were going to deliver, occurred here in Travis County at their headquarters in Austin, and as a result, venue's proper here. But we disagree with that. To address plaintiff's position, the events that give rise to this litigation all happen in Blanco County. Even though the plaintiffs quoted it in Austin and in Travis County, all the work was to be done in Blanco County. And if the court will permit me to share my screen, I've got a couple of exhibits here that I'd like to show.
Yes, you may.
Thank you, Your Honor. So we received on October 3rd, 2024, the plaintiff's initial disclosures, which included 43 pages of documents. And among them was what I've labeled as Exhibit 1. And this is Bates labeled Global Wet 3 through Global Wet 33. And it's a copy of the contract that they allege is the subject of the suit in their petition. There's also document Bates labeled Global Wet 38, which is a purchase order, and another document Bates labeled Global Wet 41, which is a project quote from Raven Construction, Inc. So I'll address the mandatory venue provision first, because I think that is absolutely the most controlling and requires the court to transfer this case to Blanco County. But looking at what I've marked as Exhibit D1, this is the subcontract agreement that the plaintiff asserts exists between the parties. And it identifies the contractor as Udelhoven Oilfield System Services, and it identifies the project as the Pedernales Falls SP Water Wastewater. Scrolling down a couple of pages, under subcontract interpretation, there is Article 6.2, which talks about law and venue. And it states, this subcontract shall be considered to have been made in and shall be interpreted under the laws of the state of Alaska. The location for any arbitration or venue for any lawsuit arising out of the subcontractor or the work hereunder shall be Anchorage, Alaska, or at the contractor's sole discretion, the location of the project. And so in this case, the reason why Alaska is in this contract is that Udelhoven is based in Anchorage, Alaska. But at the end of the day, Udelhoven has the option to decide whether to have the case be in Anchorage, Alaska, or whether the case should be heard at the site of the project. And in this situation, the site of that project is Blanco County, Texas. It's Johnson City. Exhibit D2 is the purchase order that was also produced by the plaintiff. This is Bates labeled Global Wet 38. And the purchase order that was received by the plaintiff from Udelhoven specifically identifies that this pond liner was to be delivered to 2585 Park Road 6026, Johnson City, Texas. So even that first purchase order specifically identified that the liner was to be delivered to Johnson City, Texas, Blanco County. And then defendant's exhibit 3, this is the project quote that the plaintiff received from its third-party vendor. And that quote specifically, that quote was identified as Global Wet number 41, and it specifically identifies the project location as Johnson City, Texas. And what the quote was for was crew mobilization and heavy equipment, the N45B materials fabricated and delivered, and the installation of N45B materials. Down at the bottom, the delivery address and offloading contact information specifically identifies Johnson City, Texas, or Blanco County, Texas. So not only does the contract dictate that the venue must occur either in Anchorage, Alaska, or at the contractor's sole discretion, the location of the project, but at all times that the plaintiff was working with Udelhoven in this situation, they knew that everything was going to happen in Johnson City, Texas, in Blanco County, Texas. And so this assertion that venue is proper because they made communications in Travis County, it's insufficient. Everything was to happen in Travis County, and the mandatory venue provision in the contract specifically dictates that the contractor, which is Udelhoven, has discretion to identify whether venue should be Anchorage, Alaska, or the location of the project. And so for that reason, Judge, we think this is pretty straightforward. We think the contract language is mandatory, and as a result, the court must transfer this case to Johnson City, to Blanco County, Texas.
You can bring down the screen share. And Mr. Coffin.
Good morning, Your Honor. Pleased to be here this morning on behalf of Global Wet LLC, the plaintiff in this case, the non-movement on this motion. We are asking the court to deny defendant's motion to transfer and permit us to proceed litigating this case in Travis County where we filed it. The argument you just heard goes no further than to justify Blanco County as one of multiple possible permissive venues. As I will show in a moment, there is no mandatory venue provision that requires filing in Blanco County, notwithstanding what the contract says. And further, Travis County is a proper venue, is supported by facts that I will show in a moment related to the formation of the contract, where payment on the contract would be made, and other facts. To begin with, Your Honor, I'd like to address the threshold question, which is, do we have a mandatory venue issue here that compels sending the case to Blanco County? And the answer is no. You just heard argument about a contract clause which purports to allow the contractor to essentially choose the venue location, if not in Anchorage, Alaska. Here's why that has no bearing in this. Because generally speaking, contracts for venue are unenforceable. Under Texas law, the only thing that governs Texas law in terms of venue is Chapter 15. And Chapter 15 assigns venue according to permissive venues where, on different grounds, where the facts of the case arise or where defendants live. And then, of course, there are the mandatory venues, for example, in cases where there's a dispute over land and title to land that have to be sent. And Your Honor, the default rule in most cases is a venue clause that fixes venue is not enforceable unless it falls in the mandatory provision under 15.020. And that provision says that if you have a major transaction, you can enforce a venue clause as part of that written agreement for a major transaction. Major transaction is defined as a transaction worth at least $1 million, where a consideration of at least $1 million is in play. I would emphasize, Your Honor, this is a level 1 lawsuit we have pled. We are seeking a little over $100,000 in damages on some equipment that I believe all told was under $500,000. So the mandatory, or rather the major transaction provision under the mandatory venue provisions of Chapter 15 do not apply here. They don't require the court to send to Blanco County. And there's no other basis on which they've articulated that mandatory venue provisions control. And so that gets us to permissive venues, the second level of analysis here. And on this point, it's important that you can have more than one permissive venue. And Your Honor, I would emphasize the standard of review on a motion to transfer venue when all you have at play are permissive venues is simply the court looks at the venue where the case is filed. The court looks to see whether the plaintiff has adduced prima facie evidence of their choice of venue. And the prima facie evidence is there, even if it doesn't preponderate, the plaintiff's choice still sticks. And Your Honor, on that point, I would emphasize the standard of review. I cite the cases in my response that spell that out. There are two third courts of appeals cases out of Austin that say even if you have evidence preponderating that a lot of events happen somewhere else, if you have some evidence, prima facie evidence, that substantial events underlying the case occurred in the venue where the case is filed, that's good enough, and you proceed with the plaintiff's choice. Those third court of appeal cases are the Chiraboga case and the Siemens Corporation case that I cited in my response. So with the standard of review in mind for the motion to transfer venue, I'd like to proceed now and address why venue is proper, why Travis County is a appropriate permissive venue for this case. In a breach of contract case, it is not just a question of where the agreement is to be performed. That is, we don't limit the scope of the analysis to only where the case is performed. What the case law tells us is we look at where the agreement was formed, the formation of the contract itself, along with where the obligations are to be performed, as well as the breach and any outcome there, where those outcomes occur. You look at the totality of the breach of contract claim from the formation of the contract all the way to the breach, and not simply where is this thing to be contracted going to be done. And that's a key flaw in the plaintiff's argument, because they want the court to focus on where this job is going to be done. And yes, there's no getting around the fact that this contract had to do with providing an industrial liner to a park in Blanco County. We're not going to dispute that, but there's a lot more to it, Your Honor. To begin with, this project that we're discussing, the construction project, is a public parks project. It's administered by the Texas Parks and Wildlife Department. So when you have a Texas Parks and Wildlife construction project, the decision on who's going to get the bid, who's going to get the contract to do the work on the project, those decisions are made right here in Austin, Texas, by Texas Parks and Wildlife headquarters, the administration of TPWD. And so that is what the TPWD decision to bid out contracts and award contracts here in Austin is what spurs this whole story and how this project even begins. So the key facts, Your Honor, that you need to be aware of to recognize that Travis County is appropriate is Udelhoven was a potential vendor when Parks and Wildlife put this project out for bid. Udelhoven wanted to bid on it, and that meant they needed to source a lot of equipment. For water and wastewater equipment, they knew they needed some manufacturers for that material, and who better to go to than my client, Global Wet LLC, which is a representative of manufacturers for these types of equipment. Global Wet LLC is based here. The principal of that company operates here primarily out of a home office here in Travis County. And before Oodlehoven was even able to get the contract that led them to subcontract with Global Wet for the equipment, they had to interact with Global Wet multiple times. They initiated contact with Global Wet LLC here in Travis County. They communicated all of their needs for what they needed to source the equipment. My client then communicated from its base here in Austin with potential manufacturers to gather up information about what's available. And when they gathered up all that information from potential manufacturers, they then relayed that to Oodlehoven through their office here in Austin and said, here's what we can provide. Here's what's available for your bid. Oodlehoven then bid on the project. They submitted that bid to Texas Parks and Wildlife, again based here in Austin. And then Texas Parks and Wildlife ultimately awarded Oodlehoven a contract to do the work for the project out in Blanco. Oodlehoven then went back to Global Wet here in Austin and said, we need you to provide that equipment that you helped us with the information for. Please work with your manufacturers and provide us that equipment. That is the contract, Your Honor, that we're talking about. The contract between Oodlehoven and my client to provide material that would be sourced from the manufacturers that my client has the relationship with. And so even if that material ultimately got sent to, would be sent to Blanco for installation in Blanco, the formation of that contract substantially occurred right here in Travis County. And Your Honor, in my response, I cite no less than 4 cases that say when you have a breach of contract case and you're trying to determine proper venue, you look at things like where phone calls and letters were aimed at. And if you have phone calls and letters and written communications aimed at the venue where the lawsuit's filed, that's a substantial part of the events that give rise to the lawsuit, the formation of the contract. Every one of those communications that went through my client went through Travis County. And not only that, but the contract that spurred the subcontract giving rise to this lawsuit was awarded by Texas Parks and Wildlife right here in Austin. And so because of all those facts related to the formation and the fact that my client was not paid here in Austin as they were supposed to be, you have facts arising from the formation of the contract as well as the breach of the contract that all have a connection, direct connection right here to Travis County. And that's why you have sufficient substantial facts to warrant venue under the permissive statute here in Travis County. And our choice as a plaintiff ought not be overridden simply because the plaintiff wants to move to another permissive county. The venue contract provision they cite is unenforceable. That's not how we determine venue in Texas. We determine it according to Chapter 15, and that's what we've done in this case. And so for that reason, we ask the court to deny the motion to transfer venue.
All right, Mr. Schulze.
Thank you, Judge. So what I heard Mr. Cawthon tell us is that when it works or when it's beneficial to his client, we need to look at this entire project, meaning we need to include Texas Parks and Wildlife Division, which is headquartered in Austin. Well, I'm on board with that. If we look at the entire project, now we're, instead of looking at a $100,000 claim, we're looking at a $17 to $20 million project, at which point the Section 15020 argument fails, because now we definitely have a major transaction and we absolutely are governed by the mandatory venue provision. If we don't look at the Texas Parks and Wildlife element being included of it, we just look at this contract, we just look at this claim for just over $100,000 that Mr. Cawthon filed. Well, now we have to look at the contract from the perspective of what was it for? Was this contract for negotiating the production of a liner from Austin, Texas? Or was this contract for the production and installation of a liner in Johnson City, Texas? And that's exactly what this is. The entire time that the plaintiffs got involved in this transaction, they knew that 100% of this work was Johnson City, Texas. It was not Austin. And if the companies like Oodlehoven are now going to be required to look at where they're sending text messages or where they're sending emails or where they're sending letters, we're creating an extremely slippery slope, because merely sending a letter to El Paso, Texas, for example, suddenly risks them of liability to jump into a lawsuit in El Paso, Texas, when nobody has anything over there. And that's exactly what we're looking at here. Is it's an extremely slippery slope to look at where did these cell phone calls go? Where did these emails go? If that was the only thing here, if there was nothing else, if this was a, hey, I want to order a liner from you and I'll come pick the liner up from you in Austin and take it to my job site, then I would completely agree with Mr. Coffin in this situation. But that's not what this was. The entire time that Global Wet got involved in this, the bid that Global Wet gave to Udelhoven, the estimate that Global Wet got from its subcontractor, everything dictated that this was for the creation, the delivery, the mobilization, the crew and heavy equipment, and everything that was going to be happening in Johnson City, Texas. And so for that reason, everything, all the witnesses, all of the defendants, individuals, anybody that would testify other than the plaintiff is in Johnson City, Texas. And so for that reason, the location of the plaintiff's residence in this situation is not appropriate venue.
If I may briefly respond, Your Honor, to a couple of points. To begin with, the defendants did not even raise Section 15020 as a ground for transfer in their motion. They only began to acknowledge it, note it as a possible basis for mandatory venue when they filed a reply 5 days before this hearing with some materials attached and no supporting affidavit. There is no affidavit that attached to their motion that supports the allegation that this is for a contract over $1 million. When you're determining a motion for venue, you look at the affidavits and the materials proven up by the affidavits and the pleadings. And we plead for breach of a contract where damages are for under $120,000. So their late breaking attempt to try and recategorize this as a major transaction to get it to fit, shoehorn it under that mandatory venue statute doesn't hold water because they haven't supported it with affidavit evidence in their motion or even raised it as a basis in the motion. It's only something they mention lately in their reply. Secondly, you heard my opposing counsel begin to argue against the idea that you should look at phone calls and emails during the formation of a contract. That's a quarrel he's got with well-established case law from the Austin Court of Appeals and other courts of appeals. I saw no less than 4 cases in my response at pages 5 and 6. Two come from Austin, one comes from Texarkana, one comes from the 14th Court of Houston. They all say when you have a dispute over venue in a breach of contract case, you look at things like communications giving rise to the formation of a contract. And while this contract might be ultimately about a liner installed in a construction project in Blanco County, the work that my client did to perform under this contract and even make this contract a possibility to form in the first place all occurred right here in Austin. And so he's telling you, well, it's going to be inconvenient for everybody else. Well, everybody else in this case would refer to his clients and his witnesses. So somebody's going to be inconvenienced. But the rule of thumb is you take the plaintiff's choice, and if the plaintiff's choice is supported by prima facie evidence, that's the only standard. If the plaintiff's choice is supported by prima facie evidence, then the plaintiff's choice sticks. And for that reason, we ask the court to deny the motion.
I am going to take a closer look at this before I issue a ruling, but I will try to get something to you before the week is out.
Thank you, Your Honor.
You will hear from me.
Thank you.
All right. I appreciate it. Y'all are excused from the virtual courtroom. Bowman versus Hatchings et al. Thank you
Good
for
morning, Your Honor. Max Cruiser here for plaintiffs. Just a friendly suit, prove up here.
Okay. Thank you for being patient.
Of course.
Who would like to lead us off?
I'm happy to do it, Your Honor.
Okay, go ahead, Mr. Dow.
Just to give you a little bit of background, we're here about an incident that happened regarding Aubrey Minor. She's 5 years old. This incident happened on August 11th, 2021. Aubrey was at a Chick-fil-A on West Slaughter Lane and was having a chicken nugget and swallowed a foreign object. I think it turned out to be a chicken bone. It lodged in her throat. She went to Next Care Urgent Care the following day, complaining of throat pain. There were a small amount of medicals. She was diagnosed with a sore throat. She's basically fine now, according to her parents. The case settled for $10,000, and after fees and expenses are deducted, the net recovery for Aubrey is $5,000. And unless you have questions for me, I can call Rachel Bowman for some questions.
Spellman, if you would unmute, I'll swear you in.
And Aubrey is 5 years old.
Yes, sir.
We're here because of an incident that occurred on August 11th, 2021.
Yes, sir.
And on that day, Aubrey was having a chicken nugget from Chick-fil-A, correct?
Yes, sir.
And something got stuck in her throat, and we think might have been a chicken bone.
Yes, sir.
Okay. You took her to Next Care Urgent Care the following day, and she was diagnosed with a sore throat, correct?
Yes, sir.
And my understanding from visiting with you back in November was that she had a sore throat for a few days, but basically she's fully recovered, has no problems, is 100%. Is that correct?
That's correct.
Good. You retained Mr. Caruso and his firm to bring a claim against the named defendants. And after some amount of litigation, y'all were able to resolve the claim pending this court's approval. Is that your understanding?
Yes, sir.
Aubrey's case is settled for $10,000. Do you understand that?
Yes, sir.
After attorney's fees of $3,918.03 and case expenses of $1,081.97, you understand that Aubrey will net $5,000.
Yes, sir.
Because she's 5, you understand we can't give her that money. We talked about that. If approved, we will put her funds into the court's registry. They'll earn some interest, and then when Aubrey turns 18, she'll be eligible to get those monies out plus the interest earned between now and then. Do you understand that?
Oh, I'm sorry. Yes, sir.
That was a very long and bad question on my part. Sorry. And Ms. Bowman, you and I had a chance to visit about what your options were here. You understand that you didn't have to, and you don't have to settle your daughter's case. You could tell Max, hey, I want to go try this case, and you could put it in front of a jury and let them make the decision, correct?
Correct.
And if you did that, it's possible a jury could award your daughter more than $10,000, but it's also possible they could award her something less than that, or even perhaps nothing.
Correct.
You understand that jury trials involve some unknown risk, and you've made the decision that after weighing the pros and cons of settlement versus trial, that settlement under these terms and conditions is in your daughter's best interest.
Yes, sir.
And you understand that if Judge Mangrum approves this, that neither you nor your daughter can come back against the Chick-fil-A folks or any insurance company that's involved in this.
Yes, sir.
Okay. Having gone through all that, you still believe this is in her best interest, and you're asking the court to approve it.
I do. Yes, sir.
Ms. Bowman, thank you. I'll pass witness, Your Honor.
Great. Any questions from anyone else?
No questions. We will also pass the witness.
And then from us, Your Honor.
0 questions from us, Your Honor.
All right. Mr. Dow, I'm just looking through the file trying to find the order that appointed you as guardian on this case. I assume there's one.
Well,
but I don't seem to be able to locate it.
I don't see one in my file either. Obviously, we need to file a motion and an order. I don't have it in my file. That doesn't mean it wasn't done. I don't have it.
Okay. Well, Anyone else have one? Mr. Caruso or Ms. McClure, Mr.
I'm
Robichaud?
digging through right now, Your Honor, see if I can find
Looking as well.
Okay.
I don't see one.
I can click on all of the orders in this case, and I don't see anything relative to an added item. And then I can click on motion, and I'm not sure I see a motion to appoint a guardian.
I'm not seeing one either. I see an email agreeing to.
Yeah, I just see that we had an email where we agreed. I don't see a motion nor an order.
Okay. Right. Well, the court already has the testimony from the witness. I can't approve the, I think I will let y'all file the motion. I assume it would be an agreed motion with an agreed order. Fair enough?
Fair enough.
Okay, why don't we do that? Why don't y'all send that to my submission email? And then Mr. Dow, I don't know if you wanted to offer any further testimony.
No further testimony, Your Honor, unless you just want to hear from me, but I don't plan on calling any further witnesses.
Okay. And I just want to confirm the attorney's fees are they the standard 3 1/3?
No, they're not. And I had some discussion or some email exchange with plaintiff's counsel. My understanding there, it's liability was denied, and there was actually a motion for summary judgment filed that the plaintiffs had to overcome. So the fee is just below 40% on this one. And it looks like what they did was since it's not a round number, they made the net recovery the round number, the 5,000. So the fee itself looks like it's about 39%.
All of that is correct, Your Honor. Yeah, so we took a reduction on our fees here as well. But yeah, the other thing is that this case has been litigated for over 2 years now. And we did have to overcome that MSJ here as well.
Okay, so what was, I assume there was a contract, attorney's fees agreement?
Correct, Your Honor.
Okay, and what, were there different levels of percentages based on the work or the case was taken to?
Correct, Your Honor. Yeah, it's just the difference if it's concluded pre-litigation or as soon as it's been filed.
Okay. And so was that a 40%?
That one would have been over 40% after it was filed. But here we dropped it down to 39 point whatever percentage.
Okay. Okay. All right. Well, I think we need to clean up some things before the court can approve the proposed settlement. So if y'all would handle the order, filing the motion, sending the order with it. Based on the fact that Mr. Dow has already done the work and has appeared here and recommended to the court that this be resolved, I will take that into due consideration. I want to be efficient. So, but I will hold off on approving the settlement until that gets done, because I think we have to go in a certain order about things. First things first, and then, but there won't be a need to come back for a subsequent hearing. I will handle so if you send in the motion, the order appointing the guardian ad litem, and then also send the court the final judgment documents.
Yes, ma'am.
I anticipate getting that approved. The amount of attorney's fees is a little bit higher than what I like to see for a minor settlement, but given what everyone has told me about the extent to which this matter had to be litigated and that it's consistent with the attorney-client retention agreement. I'm not gonna ask any more questions about it. I think you've clarified that for the court.
Thank you, Your Honor. If I may, on the order, if maybe we could get a motion of enforcement or an order there just to enforce. I've heard nothing from the defendant, Marjack Poultry, on this. They haven't responded to anything concerning drafting instructions. I don't know if they've sent Miss Aubrey's money to the court yet.
Okay, is Miss McClure here for them?
Yes, I'm appearing as coverage for the attorney who's on this case, Allison Kalis. She was meant to go to trial on a different case this morning. So I can certainly get with her on that for you, Mr. Caruso, because I'm not 100% sure on that. But I will definitely ask her about that for you.
Thank you. Yeah, I've tried calling and emailing, but if you could, thank you.
Yeah, I'm sorry. Yeah, she's absolutely slammed because they had a trial come up super last minute, but I will ask her about that for you.
Okay, well, you may want to think about whether you want the court to sign the final judgment if you haven't gotten the money yet, because plenary power, will run, and just, I leave that to your careful consideration, but you let me know when you're ready after the ad litem order's done, as far as entering the final judgment. Okay.
Absolutely, Your Honor. Thank you.
All right. Well, I appreciate your patience. Y'all are free to go.
Thank you, Your Honor.
Thank you, Your Honor.
Thank you, Your Honor.
Need a record for this hearing?
No, Your Honor, I don't believe we do.
Okay. Well, we're here on McCardle versus Johnson, and it's your motion to compel.
Yes, Your Honor.
I looked at the file briefly enough to know that I am unfamiliar with this particular statute that you are moving for relief under. So I leave you with that and you may proceed.
Yes, Your Honor. Thank you. And I understand that a lot of people are not very familiar with it. And this is very, very different from the hearing you had earlier. So the defendant, I represent the defendant, Johnson, Your Honor. And at the time of the incident, he was covered by an insurance policy that the business no longer exists. They have gone bankrupt. They went bankrupt in August of 2020. And the plaintiff and his counsel were both well aware of that before the suit was even filed. So when an insurance company goes bankrupt, what happens is those claims all get funneled through the state of Texas. And this sounds a little crude, but I've never found a better way to say it. It's equivalent to the food stamps of insurance, pretty much. The state will step in and tries to help out and fill in any gaps there may be. But the state is also entitled to a certain amount of offsets and credits, depending on what coverage was available or becomes available to the plaintiff for the alleged injuries that make up the suit. And so in this situation, well, first off, let me back up. It's governed by Chapter 462 of the Insurance Code, and that's quite a long chapter. But my motion and my reasoning for compelling this information is based on 462 at Section 102. In order to properly evaluate the case for any sort of potential settlement, we have to know what insurance was available to the plaintiff. And we do have some information, but here recently, in the last several months, we got a new set of records that showed that plaintiff has Blue Cross Blue Shield health insurance. Well, depending on the type of policy plan that is, it makes a difference as to whether our limits are completely reduced. Now, this is where it gets tricky, and this is where a lot of people get confused. It makes a difference as to whether our policy limits are completely reduced or whether the money that we would have to compensate plaintiff should go back to pay Blue Cross Blue Shield for any sort of subrogation claim. So we have asked the plaintiff multiple times to please provide us this certain information, whether it was a marketplace plan, whether it was a self-funded ERISA,
we can't get that information. He refuses to provide it. He did respond to our request for production, and he said that he would supplement the information, but after multiple attempts, he's decided it's not within his possession, and so he doesn't need to give it to us. The problem is it's required by the statute. We have to know. We keep going through this endless litigation, and we have a certain amount of money. Where does it go? And to keep going forward without knowing that is highly prejudicial to my client. Opposing counsel in his reply to the court said that the document we're seeking is not in his possession, and he cited the In re Colonial case. But that doesn't go to the point of what we're asking. That case is actually distinguished by the motion I filed in reply to his response. Just because it's not in his physical possession does not mean it's within his control. And it is within his control. All he needed to do was call his insurance company and find out and give us an answer. Opposing counsel or plaintiff also suggested that we should subpoena his employer to get that information. But deposition testimony, discovery responses, we can't get a response on who his employer is. If we knew who his employer was, that would solve everything. It's just a simple question. What type of plan was it? What, did you get it out of the marketplace? Was it a self-funded ERISA? Who do we pay? Does it go to Blue Cross Blue Shield? We just need these answers, and it's very simple, and we can't get a response to what we need.
Okay. All right, Mr. Ainsworth.
Judge, it looks like to me that they're asking for two things. They would like a copy of the plaintiff's health insurance policy, and they would like a copy of a form that apparently Blue Cross Blue Shield would have filed in order to establish that the insurance was of a certain character that would trigger the TP-SEGA reduction. Plaintiff doesn't have either one of those documents and has indicated that in his responses to discovery. Plaintiff has identified its employer both in answers to interrogatories and to a second set of interrogatories. In answer to interrogatory number 6 in the I guess the first set of interrogatories, he indicated that he worked for JLM Systems. And in response to interrogatory number 21, and what I think are the supplemental interrogatories, at least they were answered later, he indicates that he's a property manager for JLM Services, overseeing all leasing, accounts receivable, and remodeling. So he has identified his employer. What he talked about in his depo was that he didn't have work, he didn't have health insurance, he has work, he has health insurance. He recently had a surgery, and the health insurance information that he has was identified on an insurance card that he carries in his wallet, and that information was supplied to defendants. It's a Blue Cross Anthem policy. The card information gives the group, the carrier, his identification number for the group, and that sort of thing. So I'm not saying that the defendants are not entitled to the information. The plaintiff just doesn't have the information. It could be obtained either, looks like to me, from the plaintiff's employer or directly from the insurance company on something as simple as a deposition on written questions that the defendant has not filed. If I had it, I'd provide it. I just don't have it.
Okay. All right, Ms. Lewis.
Well, Your Honor, again, that goes to my point. There's no reason. This is within his control. This is something he can ask for. He can give it. And just like my opponent just said, he's not saying we're not entitled to this information. He knows we're entitled to this information. But just having a health insurance card, that does not give us the information we need. We've had that health insurance card for a couple of years now. We don't have the authority to call and speak to his health insurance carrier. He does. So this is within his control. And I cited case law in response to that. But not only, it goes straight to the heart of the Texas Rules of Civil Procedure 192.3B. It's not, the question is not whether he has it, he has control over it. He is the only one who can get us this information, and we are entitled to it. So I would ask that you please grant our motion.
Okay, Mr. Ainsworth, so we believe this is an employment provided health insurance plan?
Yes, ma'am.
Oh. And Ms. Lewis, do you have anything that indicates there's case law out there that says an insured, I mean, I'm not sure I could get a copy of my health insurance plan from the county or the state. I mean, maybe I could, maybe I can't. I don't know. I don't have one. And it's
Judge, I'm not trying to be facetious. I don't have a copy of my health insurance policy. And, it changes every other year. I have a summary, not that it's relevant that I have a summary of my health insurance policy, but he just doesn't have it. And if he were going to get it, he would go to his health insurance card, and then he would have to make a request to Blue Cross Anthem. It looks like that would be incumbent upon the defendant to do if they have the information, just a simple deposition on written questions, and they'll get the information they desire.
Your Honor, this is the first time we have been told that this policy has been provided through his employer. We have been told he's an independent contractor. We could never get a straight answer. We had no idea that this was, in fact, if we had had this answer months ago, we would have known exactly where we go with it. That's why we were asking him to either provide us a policy so we could try to figure it out, or the Form 5500 through his employer. But we have gone over this for months and months and months with no success. And by producing what we're asking for, we could have tried to figure it out on our own without continuing to go through all this litigation. But that's the first time he has ever said this insurance has been provided through an employer. We've asked that question countless times. So again, I would re-urge, and it's not difficult. And as a matter of fact, we don't have authority. So I don't understand why, when we've asked for these things so many times, why it's our burden to have to DWQ it and keep continuing to go through this when it's an easy phone call for plaintiff to make and say, was this a self-funded ERISA plan? If he didn't get it through the marketplace and it did come from an employer, he just has to know, was it a self-funded ERISA? This is all information we're entitled to pursuant to Chapter 462. So the fact that we even had to have this hearing today to get the answer that it is through an employer is a little bit frustrating. But I would again urge that you grant our motion, because it is within the plaintiff's control. He could easily get this information for us, and we could get this figured out.
All right. Well, I think if it were his bank account or his auto policy, which he purchased, it would be in his control. But I'm just not sure that an employer purchased policy is within someone's control. And, it may or may not be an easy phone call to get an insurance company to do something for its insured. I don't know.
Well, Your Honor, he could call his employer then.
Judge,
But
I've
his
called
employer is not
this employer.
Yeah.
They don't know if Blue Cross Blue Shield filed a Form 5500, and they don't have a copy of his policy.
That's not possible. That's pursuant to the tax statute too. That's not possible. If it's an employer, they have to file that form.
The employer doesn't file it. Blue Cross Blue Shield would file it. And so that's why the information on the health insurance card was provided.
The employer would know, and that information is not provided on the health insurance card. It's not there. We have a group number and a policy number. We don't know what kind of policy it was.
Okay. Because the court is not convinced that the policy is actually within the custody or control of its insured, the motion is denied. I think you have other options as far as a DWQ to either the carrier or the employer or both, but that is for another day and for you to decide. But seeing nothing else, y'all are excused from the virtual courtroom. Thanks for being patient.
Yeah,
Thank
Thank you, Judge. Have a good holiday.
Thank you. You too. Take care. All right. Good afternoon, everyone. Welcome to the 200th District Court. We have a number of hearings set this afternoon. I will start by reading through the docket. When I call your case, let me know you're here. Let me know the total amount of time you need for the hearing. That means both sides. And then finally, whether you need a record or not. First up is Ortega versus Perillo.
Good afternoon, Judge. My name is Cameron Cook. I'm here on that motion, but I'm the respondent. I am not the movant. Mr. Churchman is right there, so I'll let him talk.
Good afternoon, Your Honor. We are here. We need probably about 10 minutes or so. And yeah.
Do you need a record?
No.
Okay, thank you. And next up, we have Kolka versus Newman.
Yes, good morning, Your Honor. This is Larry Lawrence for the plaintiff. We're here on a friendly suit. We will need a record, and this should take 5 or 10 minutes.
And this is Ted Dravis. I'm here for the defendants, Judge.
Luke Dow, guardian ad litem. I agree with all that. 10 minutes at the most.
I think that's right.
All right, thank you. All right, and then next we have Johnson versus Wallace. Anyone here on that?
Lamar Clemens for the defendant, Wallace. It's just an agreed DCO that we submitted, and we don't need any time. I just need the court to sign it, I guess.
Okay, is the other side here as well?
Don't see him.
Okay, and you have signatures from everyone?
Yes.
All right, and has it been emailed to Ms. Seeger?
I believe so, but I'll double check with my secretary. If not, we'll make sure that gets done.
Okay. Well, if it's agreed, Mr. Clemens, I don't think you need to stick around. But if you could get it to Ms. Seeger with those signatures, I'm willing to let you go.
Okay, great. I'll do that, Judge. Thank you very much.
All right, you're excused. Thanks so much.
Thanks.
All right, next up, Mohammed versus Meeker.
Good morning, Your Honor. Alex Shamron here on behalf of the defendant, Meeker. We don't need a record, and I think this should take 10 minutes.
Your Honor, Glenn Starks here on behalf of the plaintiff. I can agree with all that, maybe even less time for me.
Okay, thank you both. All right, on the second page, that will take us to Toomey versus Lyft. Anybody here?
Yes, good afternoon, Your Honor. Emilio Get on behalf of the plaintiff. And I apologize, my camera is having some technical difficulties right now.
All right, well, you're going to need to get that worked out. We do not conduct telephone hearings.
Yeah.
Let's assume you get it worked out. How much time are you going to need?
Hopefully no more than 10, 15 minutes, Your Honor.
Okay, and do you need a record?
No.
And are you expecting anyone else to be here?
Yes, it sounded like someone was on the other side at the same time I started speaking.
Okay. Is anyone here for Lyft?
I'll call counsel, Your Honor.
Okay. Thank you. We'll get to you. All right. And last, we have Valadez versus Bonner et al.
Good afternoon, Your Honor. Kristen St. Dennis here on behalf of Bonner Carrington Construction, the movement in the motion for summary judgment. We do not need a record, and we probably need about 30 minutes. There is also a motion for continuance from the plaintiff, and I can't speak to how long we may need for that.
Vincent D'Angelo for the plaintiff, Your Honor. I think 30 minutes is probably less than that. The motion for continuance, I think, will be contained within that time.
Okay, you think we can take those up together then?
Yes, Your Honor. I mean, the objection to the motion for summary judgment is basically saying we need more time. I mean, it's a very shorthand, so they go hand in hand.
Okay, great. And no record for you either, right?
Correct.
Okay, great. Thank you. All right, we are going to go back to the top of the docket and start with Ortega. And I think there's no one here who I didn't call, right? I just want to confirm.
Your Honor, my case wasn't called.
Okay, which case is that?
It is Calvin Johnson versus Helen Wallace. Cause number is D.
Okay. Mr. Clemens was here earlier. He said y'all had worked out a scheduling order and that you would be presenting it for signature. Is that correct?
Well, we filed it, but we were told we needed a hearing to have it entered. We've agreed on a docket control order, but we were told by the court clerk that we needed a hearing to have it entered. So that's why we're here today.
Okay, let me just pull up the file real quick here.
And it was filed.
Oh, it's filed in the 353rd. Okay, normally these are handled on submissions, but that court is not handling submissions right now. So that's why you were told you need a hearing. If you have all agreed to the scheduling order, which is what Mr. Clemens represented, I'm happy to sign it without the need for you to be here.
Okay. How can we get that to you, Your Honor?
Email to Ms. Seeger. She provided the Zoom link. She's my JEA, and we'll get it handled.
All right. Thank you.
All right. Thank you so much. You're free to go.
Thank you.
Appreciate it. All right, Mr. Churchman, it's your motion, I believe.
Yes, Your Honor. This is a discovery issue. We have been trying to schedule a lot of different things with Mr. Cook and his clients, and they haven't been very forthcoming. On Friday afternoon, they finally provided a couple more documents to me. One was a second resume for Dominic Perillo, and then the other was a performance review of Mr. Perillo. I've been asking for their entire employment file of Mr. Perillo, and they still have not given it to me. They say that we have everything, but then they give me a performance review, and they still haven't sent me what those reviews were or anything of that nature. And so, plus this case has been going on for a while, Judge, and they sent interrogatories the first time and then unverified, and then came back after one of the first depositions and completely changed a lot of their answers. So then I asked for verified responses, which they also finally gave me verified agreements on Friday. So that's kind of where we're at for right now.
Okay. All right, Mr. Cook.
Yes, Judge. My name's Cameron Cook. I represent both the driver, Mr. Perillo, and a company that's called International Game Technology. And this is an international company. And excuse me, what they do, Judge, is they repair lotto machines. They're not a transportation company. They drive standard sized vehicles, just regular sized cars. In this case, Mr. Churchman, the plaintiff's attorney, has requested our entire employee file. My company has sent me, as he had pointed out, the resume, the driving record report that they got when they first hired him, Mr. Perillo's acknowledgement of receipt of the fleet policy. We've produced the fleet policy that's 27 pages. We've produced the disclosure of information that Mr. Perillo has signed. We produced Mr. Perillo's Texas driver's license. We produced photos from Mr. Perillo of the accident after it happened. We produced 2 separate sets of training lists that Mr. Perillo has gone through, both employment training lists with over 48 different classes that he's taken, as well as driver training list of 3 different classes that he's taken. And then we provided Mr. Perillo's resignation notice when he quit working for our company. And we did provide a performance and potential evaluation that was sent to Mr. Churchman. And I've got an email on my screen that I'm looking at that I'm happy to share with you, Judge, from the risk management director that states, and it lists all these documents, the exact same documents that I just went through, that states that this is our employee file. You know, these are the documents that we have. Mr. Churchman has also taken the deposition of the corporate representative for IGT, and he subpoenaed these documents. And these were all the documents that were subpoenaed that we produced before the deposition of our corporate representative. And there's nothing else there. This guy was hired in New York in 2019, and he worked with the company until 2023. And like I said, they're just a lotto repair company. They're not a transportation company. We provided, you know, all the documents that we have that we gathered for this employee, and there's just nothing else there, Judge. So, you know, I just request that the motion to compel be denied. We did provide the verifications. My driver, as I stated, he resigned from the company in 2023. He's not terribly responsive, and it's been difficult getting him to get me the verification to the interrogatories. But we got the verification to the interrogatories from the driver and from the company. And I feel like we've done everything. Like I said, Judge, if you'll allow me to share my screen, I can show you the email from the risk manager that he got from the HR department that says, this is the driver's and this is the employee's complete file. And so there's just nothing else there, Judge.
You're welcome to share screen.
Okay, great. Let me go ahead and share this. And you should be able to see what's showing on my screen is an email from Manny, who is the director of risk management. Can you see that, Judge?
Yes, I do.
Okay, and within each one of these is the actual documents that were sent for me for the employee file. This is the resume. This is the motor vehicle report. These are the acknowledgement forms when he got signed. That's the first batch of files. The second batch of file, I think, is just the MS Word. This is just his MS Word resume that Mr. Churchman said that we just produced. I had actually emailed Mr. Churchman and asked him to do a Zoom conference with me to go over these, but he didn't take me up on that. And then the last one is this one. And this is the performance evaluation that he's talking about right here. It's just a performance, a potential evaluation, and we produced this. And
okay,
then
I can only see the email now. So if you have multiple screens, it's showing the evaluation on a different screen. We're still looking at Manny's email.
Oh, so you can't see the actual Perio documents with contained in that email. It says performance, a potential evaluation.
I saw that you clicked on them and nothing opened. We're still looking at the email.
Okay, and that it was just sent to me in the email. As part of the email, do you see the email from Travis Fisher that I'm looking at?
No, I think you're using multiple screens.
Okay.
And so you have to be careful which screen you're sharing.
Yeah, I mean, it's popping up on this. Are you able to see where it says Cameron attached are the files HR has on our driver?
Yes, that is all we see, Manny's email.
And so whenever I click on this one right here, this is the last batch of documents that I got, and it's popping up on my main screen here.
Yeah, your main screen must not be what you're sharing.
Yeah, it's the same one as, you know, it's the same screen we're looking at. But nevertheless, Judge, this does have I don't know why it's not showing as some sort of Zoom thing. I mean, you can see my main screen that I'm looking at right here, right? And
all
so like
is the email.
Yeah. And so like I don't know why it's not showing the attachment when I open it up here, Judge, but I think that Mr. Churchman can attest, as he stated, that I produced the resignation notice. I produced the trainings completed notice lists of both employment training and driver training. And these things have been produced twice, Judge. They've been produced both with the corporate representative deposition pursuant to subpoena ducis tecum, which I had my corporate rep produce all his employment file. And then this motion got filed, and I went back to the risk management director, and this is what he sent me. And again, this guy was hired in New York. And, you know, it's an international company. And these are just all the documents that we have, Judge.
Okay.
Yeah, if I may respond.
Yes, please.
First off, this employee, Dominic Perillo, was hired in New York. He was hired again when he moved to Texas by the same company. They've given me only 2 different resumes and a performance and some trainings. They haven't given me anything about his actual reviews, any background checks, any other things like that. So I believe there are more things still outstanding. On top of that, Mr. Figueroa and IGT, International Gaming Technology, continuously have changed their risk management person. And so every single time we've asked for more documents, they've changed. And I think a lot of stuff has gone through the wind. And they have not produced all the necessary documents that they need to produce regarding Mr. Perillo's employment file. And I believe there are more things out there because every time I ask for more things and threaten a motion to compel, all of a sudden more stuff shows up.
If I may respond, Judge, there hasn't been any document identified by any defendant representative that's in existence that we haven't produced.
Are you withholding anything from this guy's employment file?
Absolutely not. I just showed you the email that I got from the risk management person that is directly from the HR with all the HR files that they have on this guy.
Your Honor.
And the interrogatory, has your client stated we have produced the entire file?
Well, there hasn't been a question for that, but you know, my client, I can do that. I mean, I'm more than happy to do that. And he's also scheduled the depositions of 3 or 4 of the corporate representatives, you know, yet to come.
But, Your Honor, in one of the documents that they produced was a performance review that we have not seen. So there are more documents that there are because the document that they produced on Friday has Mr. Perillo completed a performance review in June of 2022, in December of 2019, and October of 2019, and I don't have any of those.
And it's listed, that's the review is the document. I mean, it's a performance, a potential review, and the information is contained on the document that we produced. It's got rating label, start date, end date, source. It's got all this information for him that is the performance and potential evaluation. And if Mr. Churchman gets testimony from one of our defendant representatives that says, hey, there's more documents out there, I'd understand it. But nobody has said that there's missing documents. We're not withholding anything. We've given him everything. It's just a lotto machine repair company. They're not a transportation company. They're and there's standard size cars. There's not going to be all this stuff for this type of company.
All right,
This is a very big company. I find it hard to believe that there's just only 2 documents and the only thing that they have for Mr. Perillo when they hired him was just a resume.
Judge, we produced at least 10 different sets of documents.
Okay, well, I find it hard to believe. I mean, that may be what you believe, but that isn't really a persuasive legal position. I mean, they say they've given you the file. I don't know anything to the contrary. You are going to presumably take the depositions and have an opportunity to go over that. Certainly, if there's evidence they haven't done what they claim, then the court would be inclined to take action accordingly. But we think there must be more. Just,
well,
it's not going to move the needle.
Your Honor, and since Mr. Cook couldn't share his screen, this is the document that they produced, and I can try to share my screen with you. The document that they produced is just a little. Is my screen being shared?
Nope.
No, sir.
This is the document that they produced, and this is it. There obviously was achievements or things that were done to Mr. Perillo's file, but this is all that they produced regarding his performance and achievement. So my belief is that there is more things because obviously his bosses either said he exceeds expectations or he successfully achieved stuff, and those have not been produced.
That is the production. I mean, that's it. It's just an online performance evaluation that they say successful achievement or not. And there's no evidence that there is backup documents for this performance potential evaluation.
Your Honor, every time I've ever done a performance review of any of my paralegals or anybody underneath me, it doesn't just click a button and say exceeds expectations. I put in more notes or I put in multiple things. So obviously I don't believe that they're just hit one button and said exceeds expectations.
Okay, well, that is you. That is not this company, the defendant. I mean, they're representing to the court. They've given you everything that they have, and you're asking me to require them to do more. And that's really all the rules require is that you produce what you have. They've done that. So that's end of story.
Okay.
Are there other things or is that it?
That's it for now, Judge.
Okay, well, then I guess y'all are free to go. Have a great week.
Okay, thank you, Judge. Bye-bye.
Bye. To Kolka versus Newman and Poteet.
Good afternoon, Your Honor. This is Larry Lawrence here for Cameron, who's a minor. We're here on a friendly suit. I noticed that her mother was not on screen. I've checked with my co-counsel's office to see why that is. I'm not sure if her testimony needs to be elicited from defense counsel or from the ad litem in this case for the prove-up. But I'm prepared to proceed with the facts and the settlement agreement and the terms and conditions as we have them. But I'm not getting her on the screen now to serve as a witness. So I just want to let the court and the parties know that is where we're at right now.
Okay, has anybody reached out to her?
Yeah, my co-counsel's office and my co-counsel directly are messaging me that they've reached out to see what the delay is. She was provided with the link and confirmed that she was aware of the hearing. So I'm not sure if she's having a technical difficulty or maybe some other personal reason for why she hasn't in. But I just we're trying to work on that right now as you were calling the other cases, and I don't see a response, an affirmative one just yet. I don't know if the court wants to defer and go on to the next item and see if we can circle back and she'll sign on, or how the court wants to proceed. But I'm open to whatever the other parties want to do as well.
It probably makes sense to go ahead and let y'all try to track her down and go on, take care of these other cases, and certainly hope that we'll be able to get her on this afternoon before we conclude.
Okay, if the court will indulge us that after the next case, can we check back in with you to see if we have her signed in?
Yeah, that's fine. It looks like, let's see. The next case is only about 10 minutes, but
okay, we should know one way or the other by then. Thank you for your indulgence.
sure, absolutely. Thanks for letting me know.
Sure.
Good afternoon. Motion to quash and no record. Y'all may go ahead.
Yes, Your Honor, this is my motion to quash. A little bit of a history. This case arises out of a motor vehicle accident. We had the trial set for November 18th. The plaintiff's attorney asked to continue the trial. We continued the trial. My concern with continuing the trial is that they were going to open up discovery, and I did not want that to happen. So we never agreed to amend any DCOs or amend any discovery in the case. I was before the court in, I guess, the weeks leading up to the trial on a motion to compel deposition of written questions for some of the plaintiff's medical providers. And plaintiff's attorney argued that, discovery was closed, and therefore, my motion to compel should be quashed. The judge on that case agreed and denied my motion to compel. The plaintiff has now done multiple things. One is set 3 depositions. Another is file additional affidavits. And then they have also, looks like recently, filed a motion for summary judgment. I respected the court's ruling when they denied my motion to compel the deposition by written questions. And as such, I would say that the same application should be used for the plaintiff's expert depositions as well, since the court has found that discovery is closed and depositions should not proceed.
All right, Mr. Starks.
Yes, Your Honor, to give you a little bit more background. So these depositions were previously scheduled before the close of discovery. They were unilaterally canceled by defense counsel, understandably so. One of the experts lost a family member, I believe. So that deposition was canceled, at which point in time I reached out to counsel basically because it was agreed to and scheduled for a late date in October about our November trial date and possibly moving that trial date for the sole purpose of conducting these depositions. Counsel agreed, therefore we filed an agreed motion for continuance. And I'm not one of the people who write these vague ones. I wrote it very specific. Was always my intention. And it says for the specific reason of conducting these depositions, including down to it being experts and a non-party witness. That was the sole reason for the continuance. And I was under the same understanding and still am now that, of course, it's hard to write that in a DCL, but you close the discovery deadline, but you just leave it open to be able to conduct these depositions. That's it. So and either way, I'm not opposed to that. If we're going to reopen discovery, that's fine. At the time of that hearing that counsel is talking about, the motion for continuance had not been granted. And so what I brought up during that hearing is we still did not have a new discovery deadline set. And that motion was not denied because discovery had closed. It was denied because it was over breath. They were asking for personal information from my client's, one of her employers, or not really employer, it's a gym she goes to. But anyway, Your Honor, that was, to be short, the purpose of the continuance was to conduct these depositions, which were previously counseled by defense counsel. We have 3 months to do them. So I don't understand any reason why we wouldn't conduct these depositions that we both have already agreed to conduct and put in our motion for continuance. It's the sole purpose of the motion for continuance.
Your Honor, may I respond?
Yep.
I believe Mr. Starks is misleading the court. Our expert, his deposition was supposed to proceed before trial. He did have a death in the family. We worked it out with him that he would appear live for trial, so there would be no prejudice. Plaintiff's motion for continuance specifically only named him, yet he has scheduled 3 additional depositions of treaters and experts on their behalf. So, you know, my concern is that we're going to open up a whole new can of worms for a trial that is supposed to proceed in March, that was already supposed to happen in November. They objected to my motion to compel records by deposition of written questions, both for medical. We spent money on that. We had to hire a service to send out these records, these subpoenas, and they were quashed. So that's cost us money. They made their choice by objecting to my motion to compel, saying that discovery was closed. If you look at their response to our motion today, they said that that they objected because discovery was closed. That's what they included in their response brief, that discovery was closed. So you can't say it works for me now and it doesn't work for me later. So they either, we agreed with the court's ruling. We did not dispute the court's ruling when they said discovery is closed. We went along with that. We agreed with that. But now you can't come back here and say, well, discovery is open for my case.
Okay,
so
well, what the agreed motion for continuance, and I'm looking at it, it mentions more than the one expert that got canceled. So explain that to me.
Well, I had no idea they had planned on taking any of those depositions. They had never set them before trial. The only deposition that was set to proceed before trial was my expert's deposition. So that's all that was before. That was the only thing that was scheduled before the court, before this trial that was set to proceed. My understanding, my thought process here, and I don't want to speculate, is that they were not prepared. And now that they have this extension of time, this is their opportunity to take more depositions. They've disclosed more affidavits. They've disclosed more medical records. And this was my concern. My concern with extending the trial, and I can show you an email regarding this, that my concern was that they were going to open up discovery and go down this pathway. And now they have.
Well, and that's exactly what the agreed motion for continuance says. So I'm a little having a hard time understanding why you're so surprised that now the plaintiff wants to do exactly what it put in a quote agreed motion for continuance that it wanted to do. Conduct critical depositions prior to trial. Defense expert, treating physician, and potentially for non-party witnesses.
If they agreed, that they are telling the court that they don't want discovery to be open when I filed my motion to compel, then they should now not sit here and say the discovery is open. I had a motion to compel. I had motions to compel by
to a motion that says we're going to do more discovery. I'm having a hard time following that.
Your Honor, if let's just say we take what they say is true, that we agreed to continue it, then they shouldn't have objected to my motion to compel. We had this in front of the court. They objected. They said that discovery is closed. They can't now say that discovery is open. I had motion to compel before this court. They said the court should not allow these depositions by written questions because discovery is closed.
Okay, well, I'm looking at the judge's order, and it says it's denied without prejudice to defendant's right to re-urge the motion at a later date. So do you want to send out those DWQs?
Yes, and I actually did file, I know it's late, but I anticipated that something like this might happen, and I did file a proposed order with the court today. I don't know if it's happened or arrived. I did it this morning, but there was a proposed order on that issue filed this morning, granting the DWQ, granting my motion to compel and ordering that those people provide their
Was
records.
it emailed to my staff or was it filed with the district clerk?
Filed with the district court.
I
can
prohibited from filing standalone orders.
It was contained within the motion.
Oh,
amended, right. And I can show it to you, Your Honor.
All right. Well, Mr. Starks, that motion isn't really set right now, but Ms. Yamron makes a very good point. You are trying to have your cake and eat it too. It's either discovery's open or it's closed.
No, ma'am, I'm not. And I take offense to her saying that. If she were to follow what the judge said, which is to amend her DWQ for it to actually have a time limit and for it actually be limited to scope, I will not be here sitting and for this court saying discovery is closed, because that's how continuances work. Is my understanding is discovery closes, and if you file your continuance after discovery is closed, discovery is still closed until a judge grants your continuance. I'm not trying to have my cake and eat it too. I am not trying to mislead the court. I am happy to for any type of audit the court wants. I will not be standing in front of the court saying that a DWQ shouldn't go forward because discovery is closed. It's no longer closed because the continuance was granted. But I understand, counsel, I'm happy to talk about it, but I understand if she refiles her DWQ with the way that the judge stated with the actual limit to time and scope, you will not see me here arguing just discovery is closed. I have no problem with that.
And Your Honor, we requested records for the last 7 years. And so it seems like they also have a problem with us requesting records within the 7 years before today's date. And I think that's a reasonable time frame for somebody that's claiming permanent injuries and who had a history of these injuries in the past.
All right, here's what I'm going to say. Ms. Yamron, your amended motion to compel is not set for a hearing today. It was filed today. So there's no way under the local rules that for it to be set today.
Mm-hmm.
However, Mr. Starks, I do think you pushed back the trial date and you did so to conduct discovery. This is just discovery that the defendant wants.
I have no issue with it, Your Honor.
I think y'all need to work this out.
Absolutely.
And I encourage you to do so. Sending out DWQs, it takes a while to get those records back, and you're set in March. So if the defendants don't have and get everything they need in March, you're going to be back here probably opposing a continuance motion. And to the extent you previously came to the court seeking, I want this, that, and the other, but I don't want her to have what she needs, that could weigh against you. And, another judge, who knows what she might do, or he. So I'm going to ask you to confer, and please, please don't come back with something like this again.
Thank you, Your Honor.
Okay. But you understand the court's ruling as far as what was set today?
Yes, Your Honor. And I'm embarrassed to be here on this type of matter and without conferring, but thank you, Your Honor.
All right. Y'all are free to go. Have a good holiday. Take care.
Thank you, too.
Thanks. We're going to check in on our friendly suit. I think Ms. Kolka did arrive.
Yes. Thank you, Your Honor. I think she's, I saw her on camera.
You're getting back on.
And there she is.
Would turn on your video.
Hi.
Hello, we don't allow hats in the courtroom.
Oh, sorry.
That's okay. All right, thank
Go
you,
ahead,
counsel.
Yes, Your Honor. For the record, Larry Lawrence here. I represent a minor. She is represented by her mother, Sherry, who is acting as next friend. We're here on a prove up on a minor's settlement. And I don't know if Mr. Dravis wants to conduct the questioning or not. I defer to him if he wants to do that. Otherwise, go ahead.
I spoke with Mr. Dowling. He was going to do the questioning this morning. By the way, I'm sorry. This is Ted Dravis. I do represent the defendants in this lawsuit.
Okay, I defer to Mr. Dow if he wants to proceed.
I'm happy to, Your Honor. Would you like an overview or do you just want me to start asking her questions?
Why don't you start with the overview? That'll be fine.
So Luke Dow, guardian ad litem. This is a case arising out of an accident that occurred July 4th, 2022. Cameron, who is 16 now, was at the defendant's home. There was some drinking going on. The girls went up to an attic to apparently watch movies. And as Cameron was attempting to leave the attic, if you can imagine when you pull down the attic that comes out of the ceiling and there's a ladder, she fell through that and sustained some pretty severe injuries. She went by EMS to Baylor Scott and White. She was transferred to Dell for management by pediatric neurosurgery. She had several diagnoses, including a C5 burst fracture and a concussion with brief loss of consciousness. Pediatric neurosurgery recommended non-surgical treatment. They talked about a fusion, but decided not to do it. She was put into a C-collar for about 3 months, received physical therapy, followed up with various doctors, including Dr. Hartman at MD Spine Care, as well as Central Texas Brain and Spine. She is now being homeschooled. Her neck still gives her some trouble, but is otherwise doing okay. The settlement is for $380,000. It's a $500,000 homeowner's policy. And after fees, expenses, and a Medicaid lien, the net recovery is $227,371.22, all of which is being placed into a MetLife structured settlement. So, Your Honor, if you have questions for me, I'm happy to answer them. Otherwise, I would call Ms. Kolka for some testimony.
Okay, let's call her first. If you'd raise your right hand.
And she's 16?
That's correct.
We're here because of an incident that occurred July 4th of 2022 at the defendant's home, correct?
Correct.
And you heard my explanation to Judge Mangrum about what happened. The girls were up in an attic and she fell through that attic ladder door thing, correct?
Correct.
I don't know a better word for it. But she was injured pretty severely, correct?
Yes.
She was taken to Baylor Scott and White, but they transferred her to Dell Children's Hospital.
Yes.
She was put under management by pediatric neurosurgery.
Yes. However, she was not taken to Baylor Scott and White via ambulance. The kids actually drove her there.
Okay. And then she was transferred to Dell.
Transferred via ambulance to Dell. Yeah.
Okay. And amongst the main diagnoses that she was given was a C5 burst fracture and a concussion, correct?
Yes.
All right. No surgery was performed. It was discussed, but it was decided to not go through with surgery, correct?
Correct.
She, however, did have a C-collar for about 3 months and went through a pretty extensive round of physical therapy.
Correct.
Okay. And she's also followed up with various neurosurgeons and orthopedics on her neck, correct?
Correct.
My understanding is that she's now being homeschooled, and she does have some problems with her neck, but otherwise is doing pretty well.
Right.
Okay. You engaged Mr. Lawrence and brought a claim against the named defendants, litigated the case, and were able to arrive at a settlement, I believe, after a mediation, correct?
Correct.
Okay. And the amount of that settlement, pending this court's approval, for your daughter is $380,000. Is that correct?
Correct.
And you understand that out of that, $134,531.49 is being deducted to pay attorney's fees.
Yes. Correct.
And there is a Medicaid lien of just over $18,000 that's being repaid, or I should say a healthcare lien.
Right.
Okay. And once those deductions are made, Cameron's going to end up with $227,371.22.
Correct.
Okay. We've had discussions, well, you and your lawyers and you and I had a discussion about what to do with this money, right? There were UTMA accounts, there were structured settlements, and ultimately what you chose was a structured settlement through Metropolitan Tower Life Insurance Company.
Correct.
And that will pay out as follows. When she's 18, she'll receive $50,000. When she's 19, she'll receive $50,000. When she's 20, same thing, $50,000. When she's 21, she'll receive $50,000. And then when she turns 22, she'll receive a final lump sum payment of $58,627.
Correct.
Does that all comport with your understanding?
Yes, sir.
Okay. Now, you understand from talking to Mr. Lawrence and to a lesser extent me, the fact that you don't have to do this, right? You could take the case to trial, a jury would hear it, and they might award Cameron more than you've settled for. That is a possibility.
Correct.
However, the flip side is true, and a jury could hear all of this and award her less money or even no money at all. That's possible.
Correct.
You've had a chance to weigh the risks and benefits of trial versus settlement, and you've come to the decision that settlement per these terms is in Cameron's best interest.
Yes, correct.
And you're asking the court to approve all of this, including the structured settlement.
Correct.
Okay, ma'am. Thank you very much. I'll pass the witness.
Thank you.
Mr. Lawrence?
Yes, I think Mr. Dow covered everything I was going to ask Ms. Kolka, so I would pass the witness at this time.
Mr.
And-
Dragos?
I would say this is Ted Dravis, and I will also pass the witness. I think Mr. Dodd covered everything.
Yes, and we would ask the court to approve the settlement, Your Honor.
Okay, thank you. All right, Ms. Kolka, you're here this afternoon asking that the court approve this agreement.
Yes, ma'am. Yes, Your Honor.
Okay, and you think, given all of the possibilities that sitting here today, this is in your daughter's best interest?
Yes, Your Honor.
Okay. All right, Mr. Dow, would you just, if you would break down the numbers for me in percentages, if you can? Or at least the attorney's fees.
Sure. I think the attorney's fees are right at a third. So the total settlement's $380,000. And the attorney's fees are $134,531.49. Let me.
Mr. Dow, let me interject.
Yeah.
The sheet that I'm seeing has the fees at $126,654.
Okay, so maybe that extra amount are case expenses.
Those are case expenses. Yeah, exactly. Of $7,877.
Okay. Sorry, that's what Mark had sent me. So correction there. So Your Honor, 126 into 380. I think that's right around a third. But let me.
Yep. It is. Thank you.
Okay. And then that healthcare subrogation claim is $18,097.29.
Okay. And what is the timetable for the MetLife structure to be funded, or has it been accomplished?
I don't think
sorry, Luke. I
Go ahead,
apologize.
Ted. No,
It's
go ahead.
not accomplished, but Judge, it'll be done, I would think, within 7 to 10 days, probably closer to 7. The only thing that may interrupt that is the holiday next week.
Okay. All right. Well, I don't have any further questions. Ms. Kolka, I'm sorry to meet you under these circumstances, but I'm glad you have reached a resolution that makes sense for your family.
Thank you.
All right. So the court will approve the settlement and enter the final judgment. Have you already sent that to Ms. Seeger?
I sent it before the hearing, Your Honor, and it's got all of the MetLife payments in there as well. It's an exhibit.
Okay, great. All right. Well, I appreciate it. Thank you for your patience in the virtual courtroom.
Judge, the only housekeeping event is that Mr. Dow and I have agreed on his ad litem fee of $3,000.
Okay.
And
And
that was put into the final judgment.
okay. Okay. And Mr. Lawrence doesn't have any concern with that?
No concern on my part, Your Honor.
Okay. All right. sounds like we're all on the same page then. Thank you for your time. You are free to go. Have a wonderful holiday season, rest of your week.
Thank you. Happy holidays, Judge, and everybody else.
Mr. Guerra. Yeah, you got your camera working.
I did. It's a new computer, and I hadn't had issues with my camera before, but I apologize, Judge. Like I got it sorted out.
Okay, no worries. Give me just a second to switch cases here. Yeah, I read through the affidavit here. You have a bad address, and I want you to tell me what you have done to find a good address.
Yes, and just so that the court's aware, this is an unopposed motion for substitute service. Ordinarily, this would be taken up by written submission, right? But it's my understanding that the judge who would ordinarily enter the order for it, she's not up for re-election. So I was directed to set a hearing for this motion. It's unopposed. I know counsel for Lyft, he's not here. I was able to reach out to him during our break, and he sent me an email saying a conflict came up with him, but he's fine with me going forward with this hearing without him.
Okay, and let me just stop you right there because I want to make sure we're all on the same page. Judge Connor actually reviewed this by submission, and she denied it. Okay, I'm looking at a docket note from October 17th of this year, in which she makes it clear that there was only one attempt at service, and the affidavit from the process server said the person doesn't live there.
There may be some confusion, Judge. I had filed an amended motion for substitute service, so I'm not sure if what Judge Connor looked at earlier was the original motion or my amended motion. After I filed my amended motion, I had my staff follow up to see where Judge Connor was on reviewing the amended motion in the order, and that's when I was told she had not looked at it, that she would not be ruling on it, and that I needed to set it for hearing.
Okay, fair enough, but I just want to make sure you understood it was denied. The prior.
Yes, yeah, this was before I had the case, Your Honor. That is my understanding of what happened before I took over the case, so we're on the same page there.
Okay, and then in reviewing the amended motion, I do not see where you have attempted to locate a good address for Steinberg, which I think is required by Rule 106B6. So why don't you walk me through that?
So we had a private investigator look into Mr. Steinberg. Clearly, he doesn't live at the address that was identified in the police report or his driver's license. They looked into potential other places he could be located. I think there was 1 or 2 addresses in Texas, 1 in Florida. He wasn't there. So what my amended motion asks for is to serve him under the new rule of 106, which would include email. So this is a motor vehicle collision, and Mr. Steinberg was using the Lyft platform technology as a driver. He was in the process of using the Lyft platform technology to pick someone up when the collision happened. And so whenever someone wants to drive for Lyft or Uber at any of the number of transportation network companies, they have to provide various personal information to Lyft or Uber, what have you. So he was actually required to provide Lyft with his email address. And so in the documents, it's in Exhibit 1, Your Honor. It's referenced in a couple of places, including Bates number 000144. He provides his email address that he was required to do with Lyft. And so that is the basis of my motion, because we were not able to find him, but we know his email address that he was required to send to Lyft. The basis of the motion is to serve him, pursuant to the new 106 rule, which would include email.
Okay, so let me go back to the motion here. I did not see where a skip trace or any attempt to find a good address was set out in the affidavit of the process server. I see where he tried to serve what we know is a bad address, and then it seems like from that, we're just going straight to email. So, I mean, you told me you did that, but I think the rule requires that to be sworn in front of a notary and attached to a motion such as this. So I may have missed it. Let me know.
Exhibit 3, Your Honor, to my motion shows our process server trying to go out to Florida with an address that was associated with Mr. Steinberg. And he had a relative that lived there, and the relative told the process server, no, he doesn't live here, and we don't know where he is.
Okay, do you know, sorry, you have a 164-page document here, so if you have any idea where I might be able to locate that, it would be helpful.
Yes, this morning, Your Honor, I uploaded the exhibits separately in 3 separate PDFs, so that way it wasn't just a single, PDF with everything combined. I uploaded it to the box.
Okay, so exhibit 1, 2, and 3, which one do I need to look to?
So we were just talking about exhibit 3, Your Honor, where the process server went out to a Florida location that turned out to be related to Mr. Steinberg.
Okay, this is a return of non-service. Let's see. Okay, from the uncle.
Yes.
No address and no phone number. Okay.
If it's also helpful for the court to look into this, in exhibit 2, that was the original Leander address we thought was associated with Mr. Steinberg, and the process server does put in there that the above address is the only known address associated with the defendant in the state of Texas.
Okay, and this is from back in September. So presumably Judge Connor already had this when she denied this motion. So I guess I'm really trying to figure out if you have exercised due diligence in finding where this person lives. And I could not find that from the motion itself. And her docket note was very clear that she did not feel that any diligence had not been exercised as far as a skip trace or a PI or tracking down this person.
It's, if I may, Your Honor, it's my understanding that when the original motion for substitute service was filed, the only search that was conducted was at that Leander address. And the motion itself was asking for the court to allow service by publication as opposed to email or some other means.
Okay, then let's talk about the email address. Have you made any attempt to contact the defendant through that or to confirm that that's a good address, that it's still in use? Is he driving for Lyft to this day? Will they confirm it's a good address?
I have not undertaken that, Your Honor. I've had other Lyft cases before, and I know this is probably not a situation where I would want to ethically reach out directly to Mr. Steinberg. All I know is that it's undisputed that he was using the Lyft technology at the time, and that he was required to give Lyft with a good email address, and that's what the documents show that are attached to my motion. That being said, I have not tried to email Mr. Steinberg to that email address myself.
Okay, well, Lyft is a party to the case, right?
Yes, but the attorneys that represent Lyft do not represent Mr. Steinberg.
I understand that, but they have information about whether he still works for them, whether they have contact information. They're required to give you disclosures. So I don't understand why we don't have better information on finding this guy. And you have another defendant who you presumably could easily ask. So have you asked? What have they said?
The documents that I attached to my motion, Your Honor, were from disclosures. They were documents that Lyft produced in response to their disclosures. They were not something I got on my own investigation. They were from Lyft's attorneys.
And what is Lyft's last known address for this guy?
It would be the Leander location that he no longer resides at.
And what about, does he still drive for them?
I don't know the answer to that, Your Honor. I do know that, under the statute, people that drive for transportation network companies like Lyft or Uber, they're not considered employees. So I'm not sure, if Lyft or Uber is, continually obtaining information from people, because all it requires is those drivers just stop using the platform, and that's kind of it. They're not considered employees.
Okay, so I'm just gonna go back to Rule 106 on service. You're clearly trying to use B, which says it's got to be supported by a sworn statement listing any location where the defendant can probably be found and stating that service has been attempted and not successful, and only then at that point can the court either authorize leaving a copy or social media, email, etc. And where I am is, before I even get to the email or social media, you are supposed to have a sworn statement telling the court where this person can reasonably be found and that you haven't been successful. And I only see one part of that you haven't been successful, but there is supposed to be due diligence to get his location. So that is the missing link for me. And I don't see that in either of these three exhibits. Let me look back at the first one. Oh, the first
Yes,
one.
the sworn statements are in Exhibit 2 and Exhibit 3, Your Honor, not Exhibit 1.
Okay, all right. Well, let me look at, okay. And I think that's the problem with 2 and 3 is that they don't say where the defendant can be found. They say the opposite. These are 2 different addresses where we now know the defendant is not located. It's not located up in Cedar Park. It's not located, or I'm sorry, Leander. And it's not located in Florida. And yeah, I mean, if I'm just looking at the rule itself, which is what I tend to do, you first have to show the court where he can be found and that you haven't been successful in serving him where he can be found before you go to an alternate. And here you've said, well, we tried under the places that we know, but they're wrong. So they're really not places where he can be found. So I don't know that gets you there under Rule 106.
My response to that, Your Honor, would be, a police report was made. It listed his address on the police report. That was the place that we thought he could be found. And our process server goes out there. That's the Leander address that's in Exhibit 2. And he doesn't reside there anymore. And the only reason why our process servers knew to check in Florida was because they did a skip trace on him and another address popped up, and it was that Florida address. And he doesn't live there. It is a relative that lives there, and the relative doesn't even know where to find him. And so going back to the information he provided to Lyft, which is attached to my motion as Exhibit 1, the documents that Lyft's attorneys provided us in response to initial disclosures, Mr. Steinberg provided his information to Lyft. It included that Leander address for whatever reason he's not there anymore, but it also included that email address.
Okay, so I think the problem is some of what you've told me is not in the exhibits. Like the fact that an investigator ran the skipped race. That you're telling me that, but that is, the rule says that information must be sworn. You know, I mean, I'm just looking at 106B.
Exhibit 2, Your Honor. It's the affidavit from process server Robert McMullen. He does include in there research was done to find the most current address of the defendant. He includes that statement in his affidavit.
Okay, but you have to understand, Judge Connor denied this motion and she had that very same affidavit. And so, I mean, I think I agree with her. I don't see that you've exercised due diligence. I think you need to do more. And when you come back, I think you have to, everything that has been done to track this guy down needs to be in the sworn affidavit. Because the totality looks like you tried service at 2 bad addresses, and now you want to move straight to email, which you haven't bothered to ask Lyft if that email is still good, if he's still driving for them. So the court does not know whether that is going to effectuate service. Service, a process, it's constitutional. So this is not a small thing, you know. So I'm going to deny it without prejudice. You are welcome to come back again and hopefully have more information for a judge to make a different decision.
Appreciate your time, Your Honor.
Okay, thanks for your patience. You are free to go.
Thank you.
Have a good day.
You too.
We are here. Okay, let's see. You have a summary judgment. And I did take a peek at this one a little bit, so not extensively, but I have a general understanding of what your positions are. And y'all got a trial, what, in the spring?
Yes, sure.
Okay. Well, I'm fine for y'all to just argue it all together. And Ms. St. Dennis, it's your motion, so you can start us off.
Sure thing. Thank you, Your Honor. Good afternoon. Chad Geisler and I represent Bonner Carrington Construction, which I will refer to BCC for ease rather than saying Bonner Carrington Construction over and over. It gets tiresome. We are seeking summary judgment on the basis that plaintiffs have misidentified BCC and is not a proper party because it did not construct the apartment complex, which is called the Cypress Creek Apartments. It did not repair the apartments, has not managed the apartments, and has never maintained the apartment complex. For these reasons, BCC did not owe plaintiffs a duty, and there is no special relationship that exists between plaintiffs and BCC because the entity has no relationship to the apartment complex. This case arises from a personal injury incident in which a child fell from an apartment window. The apartment complex was the Cypress Creek Apartments. This incident occurred in May of 2022. However, plaintiffs did not add BCC until April 2024. The Cypress Creek Apartments were originally built in 2004, and it's worth noting that BCC did not exist until 2007. After some investigation, Mr. Geisler and I determined that BCC is not a relevant party because, as I said, it was not in existence when the Cypress Creek Apartment complex was constructed, and it would not, and therefore it was not involved in the construction. It has never been involved in the repairing of the Cypress Creek Apartments, and it has never been involved in the property management aspect of the apartment complex. As identified in one of our co-defendants' interrogatories, Ameristar Screen and Glass is identified as maintaining and repairing the windows on the Cypress Creek Apartment complex. After this discovery, after this investigation, we offered to present our corporate representative for deposition and also presented an affidavit from Lisa Hodges, who serves as general counsel for Bonner Carrington LLC. We then subsequently answered discovery and once again offered our corporate representative for deposition. We ultimately ended up preparing our corporate rep for deposition, which we believe was going to occur on November 13th. The day before, I spoke with plaintiff's counsel, who in Mr. D'Angelo's defense is his predecessor, and plaintiff's counsel ended up pulling the deposition the day before. In a phone call, I asked Mr. Hernandez whether he needed to reset the date or what else he needed to identify, exactly what he needed to identify in regards to the veracity of the fact that BCC has been misidentified. And so far, we have not received an answer. Mr. D'Angelo is now on the case, and we ended up filing our notice of hearing to set our motion for summary judgment, which had been on file since August 20th, 2024, following the conversation with Mr. Hernandez, because he could not identify what else he needed to determine that BCC had been misidentified and has had no relationship with the Cypress Creek Apartments. Therefore, we would seek summary judgment as no duty exists because no relationship exists between Bonner Carrington Construction and the Cypress Creek Apartment Complex. I will note in my conclusion that the plaintiffs have still yet to identify exactly what they need from BCC and why they need it from BCC before they either dismiss us from the suit or add the proper part. Thank you.
Mr. D'Angelo.
Good afternoon, Your Honor. Yes, first of all, I want to apologize to the court. I apologize this morning to counsel that I misread. I confused two discovery responses. There are, you want to notice in the caption, there's 4 Bonner Carrington entities. And I quoted about having a minor ownership interest from the Bonner Carrington LLC answers to interrogatories, not the Bonner Carrington Construction LLC. So those exhibits and that argument is entirely wrong. And I apologize for my oversight this morning to counsel, and I hope the court didn't waste too much time reading that portion. I do not dispute, the plaintiff does not dispute the fact that it appears, based on what Ms. Hodges has said and the accompanying documents, that Bonner Carrington Construction did not build the apartment building. And I point out that part of the factual underlying is this window, the bottom of the window is only 12 inches, 12 to 14 inches is my understanding. It could be 13 or 14, but it's about 12 inches off the floor. So it's a very low window that the child went through and received serious injuries. However, the issue is precisely that we need to find out all we have right now is an affidavit from Lisa Hodge, who is the general counsel of Bonner Carrington LLC. I don't really know, other than the fact that my common sense would tell me there's a lot of overlapping ownership and control in these various entities just by the nature of the names. But, that's common sense. And as you want to point out in another hearing, my beliefs don't state the law or make the law. That's a very interesting, so what we need is we want to find out what is exactly the relationship between these. The only evidence offered by defendants is the conclusory affidavit, other than the fact that they didn't build it. I'll grant that. That's pretty explicit. Conclusory affidavit from Ms. Hodge. And so the person we want to take, the first deposition we tried to take, not necessarily, it's a little unclear in some of the correspondence, want to take Ms. Hodge's deposition. That's what they offered up. Here's the evidence they offered up saying, we have nothing to do with it. Well, and the objection to that is apparently she's general counsel. And so some stuff may be attorney-client privilege. Well, or work product. I don't know that you can have it both ways. This is your affidavit that says here, we didn't build it, and now I'll concede that. There's no question. We didn't build it, we didn't maintain it. We know that one of the other co-defendants does make mention of this window company, but it's not clear whether they did inspections or whatever. We really need the opportunity to take the deposition, start with Ms. Hodge, figure out what we're going to do, and where we're going. And we may well end up where my colleagues and counsel wants. We may end up withdrawing. I'm sorry, bad terminology. I come from another jurisdiction. We may end up non-suiting the Bonner Carrington Construction LLC at some point. But this case has only, as with regard to Bonner Carrington Construction, I'll say BCC, I agree, it's much easier to say. BCC, only was added to this suit in May of this year. They answered the interrogatories. Again, I had the wrong entity, so I said November. It was really the end of September that the interrogatories were answered. I took over this file. That's not really an excuse, but I did take over. I was assigned the file November 21st, the Thursday before Thanksgiving, and I was scheduled to go to Connecticut the whole week before I got this file the following week. So I've not had it very long. And that's hence the whole opposition is that we still have a lot of time left. I think the discovery deadline is not until April, I believe, and the trial's in May. Just that for either as a no evidence or a traditional motion for summary judgment, we need time. I know exactly what we need to do. I need to start out with Lisa Hodge. She's the one who was whose affidavit was supplied, and then from her, what she knows and who she can identify in that deposition. And then I go take depositions of the other Bonner Carrington entities, and that's really our position. Not that ultimately the motion may not have. I just don't know. The motion may have merit, and that's why I filed. And again, I apologize to the court. Originally, I filed an objection, not realizing that a written response does not mean an objection. It means it has to have the word response in it. I was corrected on that. And again, I apologize for my ignorance. I'm getting there little by little. But that really is basically it. We need more time. And I'm really asking, I think the continuance is better than a denial, because I don't know that I'm not looking really to have it denied unless it has to be heard today, so much as continued until we complete discovery.
Okay, and Mr. D'Angelo, you're not satisfied that you can make a decision on behalf of your client without getting the deposition taken?
I can't. I have to do more due diligence, Your Honor, to do that. And believe me, I'd like to get rid of some of these parties. I mean, I'm not a great believer in having 15 parties when one will do. It doesn't really advance my cause. And I look at a larger picture than just how many people can I add to the party. I like small, intimate parties, not large, loud parties.
Okay. All right, Ms. St. Denis, your motion, you get the final word.
Thank you, Your Honor. If I may, our concern is that we have offered to present our corporate representative since June of 2024, and thus far, plaintiffs have not taken us up on it, which is why we set the hearing for a motion for summary judgment. We are concerned that our client will be prejudiced in terms of continuing to defend a case in which it is not a proper party. And so we would request our motion for summary judgment be granted because we feel that we have offered our corporate representative for deposition numerous times and have thus far been left waiting. As well, Mr. D'Angelo, I believe now is the third attorney that I've worked with since we've been added to this case, and I'm concerned that if that pattern continues, we may not get a corporate representative deposition for another 6 to 9 months.
Okay. I understand where both of you are, and so here's what we're going to do. In the next 45 days, you need to get that deposition scheduled and taken. And after that, the summary judgment can be reset starting February 3rd. Okay, so.
May I ask a question? Sorry.
Yes, go ahead.
You say the deposition. They want to offer one corporate representative who is the president, I think, I may be misquoting his title, of Bonner Carrington LLC. I want to start with the deposition of the person whose affidavit was given in this case, which is Lisa Hodge. I may want other depositions after that, and I will move as quickly as possible to get them done. I do not want this to drag on. I really don't. And besides, we have a discovery deadline coming up in April. So I can get a date for this other deposition the first week of January for Hodge, if they'll give us, if they will produce Ms. Hodge. And I can even right now, and based on that, I can get a deposition of anyone else. I get notices out, again, depending on the cooperation. And I'm not saying, please, I'm not suggesting opposing counsel has been uncooperative. If I find those are the names I want, I can give names and I can give dates of when I want those very quickly. I don't need 6-7 weeks. This is not rocket science, and I don't mean to insult anybody, but this is pretty basic factual discovery, and I can move very quickly on this so that within 45 days we'd be done. But, you know, I can't do anything for the holiday period just because I hate to say it, we're closed next week and then we're the very short week. But I'll do it next week if they have to. I'll come in.
All right, well, I am fairly confident that 45 days gives you enough time, even in light of the holiday weeks that are going to be lost. And Ms. St. Dennis, you and Mr. Geisler only represent Bonner Carrington Construction LLC. And so
Yes, sir.
my rulings are related to whoever is going to be presented as the corporate rep for that entity. Now, I think Mr. D'Angelo has raised the issue of, well, it's a lawyer, you know, a lawyer may or may not be the best person to be a witness in a case that may cause more problems than it solves. But that is not what is in front of me. I think y'all need to talk about what the list of topics are. And I mean, given the allegation that this entity didn't exist, it might be a very finite list of topics. And it might be a very short deposition. Or it might not. I don't know. But I think when you put your heads together, 45 days is going to be plenty of time to get this sorted out. So I anticipate February is going to be fine for resetting the motion. Or, in fact, if everything shakes out the way the defendant says, maybe there won't be a need for hearing. I don't know. Time will tell.
Thank you, Your Honor.
Understood. Thank you, Your Honor.
All right. If y'all want to put together a motion, I mean, an order consistent with what we talked about, it can be emailed to Ms. Seeger.
Understood. We will get that together and get that over to Ms. Seeger.
Yeah,
Okay.
I'll call closing counsel as soon as we're off this, as soon as we're off the Zoom.
All right. Well, thank you very much for your patience this afternoon, and have a wonderful holiday season.
Thank you, Your Honor.
You're free
Thank
to
you,
go.
Your Honor. You as well.
Good luck. Yep.
Thank you.